Okay then, thank you very much everybody. The time is now 9:30 and this inquiry is resumed. First of all, to introduce myself to those who haven't been before, my name is Helen Hockenhull and I am a Chartered Town Planner appointed by the Secretary of State to hold this inquiry. Now this inquiry is into an appeal by Lee Huff and Co. under Section 78 of the Town and Country Planning Act 1990 against the refusal of outline planning permission by Chorley Borough Council for the erection of 123 dwellings on land adjacent to Blainscough Hall, Blainscough Lane in Coppull. Just a few housekeeping matters, as always. Mobile phones, can you please turn them off or on silent? Anybody from the press here? Anyone intending to record the event? No, thank you. Attendance list, is that circulating? Yeah.
It is, and I've got yesterday.
I was going to say that I didn't get that yesterday. That was my fault for forgetting about it. Thank you very much. Super. Yes, so can everyone please sign the attendance list who's here today? And hopefully I'll remember to pick it up this evening when we finish today. Can the council please advise, is there a fire drill today and what is the fire evacuation procedure? No drill foreseen. Okay, that's wonderful, thank you. Any outstanding matters from either party? I have a number on my list, but anything from Mr. Potter? Mr. Cannock? Right, okay. Matters that I want to raise then. First of all, I think we have Mr. Winstanley with us today, is that correct? Yes, I know you wish to speak. So what we're going to do is hear from you first, if that's all right. Yes, Councillor?
Madam Inspector, could I just raise the early in the week on Monday you expressed the opportunity, there was an opportunity for speakers to come back to ask questions or to clarify some situation. I think you did actually mention it be today. So are you mindful as to when that might be, please?
That is usually after Mr. Pontus finished his cross-examination.
Okay, sorry, could you just indicate when that is?
Mr. Pontus over here. So it's when he's finished asking questions of Mr. Saunders, I will have an opportunity to ask questions and then I'll bring you in at that time or anybody else who wants to ask questions before Mr. Cannock then re-examines.
Brilliant, thanks very much.
Okay, so that's the process. Okay, so that's fine. I also understand we've got Councillor Hilton who isn't able to join us until 2 o'clock this afternoon. So we will hear from Councillor Hilton then. I am also aware that the MP wishes to come and address the inquiry and that's going to be tomorrow morning at 9:30. I want to turn now to education evidence. First thing on Monday morning, Mr. Cannock, for the appellant, let me have a hard copy of various papers and an addendum to Mr. Powell's education statement. That information, there was an accompanying email with that made reference to a further updated education assessment that provided the basis for a partial contribution. Now, I haven't seen that. I'm not sure which party should have sent that to me, as it's something that's prepared by the Education Authority. But I've checked all my bundles and emails. I haven't got a copy of that assessment, which clearly is quite important.
Yes, ma'am, and I'm not entirely clear the email to which you're referring, but I think that might be a reference to the Lancashire County Council.
Yes, I think it is.
Is that right? So I think, ma'am, you might not have seen something from Lancashire County Council. So I'm not sure I'm the best person to answer that, but what I might do is ask if Mr. Bullock can perhaps make contact. Either we may have it. We can forward it on to you then.
Yeah, no, that's fine. That's the problem I have with this, because it isn't really the council's responsibility or really the appellant's responsibility. It's a third party. The email, I think, was from Mr. Bullock late on Friday, which I didn't get till Monday morning anyway, which referenced this discussion about a partial contribution. There was nothing within that email or in the hard copies you gave me on Monday that provided that information, which clearly is crucial to our discussions this afternoon. So at this stage, I could really do with a hard copy rather than an electronic copy. That would be the easiest option for me. If someone can provide me with a hard copy, then I can look at it over lunch
Yes, we'll liaise with the council and try and get hard copies. I think we've got the information on, so it's just a question of getting it printed and to you.
Okay, that's fine. We've got all morning to do it. I'll have a look at it at lunchtime. Following on from that, I also received an email yesterday from Lancashire County Council suggesting they had some further evidence they wished to submit. Have either party seen that? It included a report from the Cabinet in September and also a short statement in rebuttal to the 6th of October further addendum that Mr. Powell produced. A further critique of that. It's about 3 pages long. Have you seen
I've
that?
seen it,
You've
madam.
seen that,
There was
right.
forwarded to us on the 12th of October. So that
Yeah,
was,
I saw something yesterday, late yesterday.
that
I saw
was
something.
yesterday, wasn't
Yes,
it?
was.
That,
Very, very late in the day.
at about midday, forwarded to us was an email that we were copied in on Miss Currar was copied in on.
Right.
And it went to Mr. Bullock at the appellants as well, I think. So we've seen it.
Right.
And I assume the appellant.
This is why I'm asking the question now, just to check that everybody has seen it. So I haven't actually said whether we're going to accept this information at this moment in time, but I'm just
Well, the
checking
answer
the
is-
email exchange has occurred.
So I think we're being told there was something circulated by email from Lancashire County Council yesterday.
Yeah.
Mr. Bullock is not aware of having received that. I've certainly not been told about it, and I've certainly not seen it. I have seen the statement of common ground with Lancashire County Council, which, dare I say it, Ma'am, is pretty absolute and unequivocal. So I confess I'm a little surprised, halfway through an inquiry, to be receiving what may be technical evidence. Now, I'll reserve my position, Ma'am, if I may, until I've perhaps had a chance to read it and understand it. But at the moment, I think I would want an explanation for Lancashire County Council as to why they are submitting any evidence beyond what's in the statement of common ground.
Well, I tend to agree with your assessment there, because I wasn't particularly happy with receiving it at such a late stage. If it's very simple information, that might be absolutely fine. But what I have seen is it's a cabinet report which looks at the adoption of the current methodology that State Education have. And there was 2 or 3 pages of critique of the addendum of the 6th of October.
That's what we've received.
Yeah.
And the email was sent from, if it helps Mr. Bullock, the email was sent from Mr. Terry yesterday at 19 minutes past 12.
All right. Right. And my view at the moment is I'm not inclined to accept it, but clearly Mr. Terry can verbally address the addendum and whatever comments he wishes to make, he can do that verbally this afternoon. But we'll address it later on. But I'm just checking what the position is from all parties. The key thing for me at the moment is just having the hard copy of this further assessment that leads to the suggestion of a partial contribution. And I've got an opportunity to read that before this afternoon. Okay, thank you. The only other thing I wanted to mention was that I do have the revised draft 106 from Shoesmith. I've seen that email has come through to me, so I have had a look at that already. Just to confirm I've got that.
Madam, I understand that the terms of that are now entirely agreed between the appellant and the local planning authority.
Right, that's lovely, thank you. Okay, so that's all the updates and additional things I need to mention right now. So we'll now then turn to Mr. Winstanley, if he would like to address the inquiry and explain his views on the proposal. Yes, if you can use the microphone there, yes, that's fine. Okay, thank you, Mr. Winstanley.
Okay, thank you, Madam Inspector, for giving me this opportunity to voice my opinion. Obviously, I live at number 64 Manor Way, Coppull. Obviously, when I purchased this property, I was led to believe that this is safeguarded land, I believe, until 2026, which I'm sure you're more than aware of. It is listed as Greenbelt. And to my opinion, there's never had any buildings erected on it. Where we reside, we do see regular current wildlife, which obviously if this gets the go-ahead, will be affected. And obviously, another point, during heavy downpours, I have witnessed manholes being blown off in Grange Drive. And further development of over 100 properties will only bring this unwarranted flooding in more surrounding areas. With regards to the entrance, although I have not witnessed any serious incidents or accidents, Grange Drive is already a hazardous entrance. More housing again will enlighten this and bring this more, intensify this risk. Chorley and its surrounding villages, in my opinion, to what I've read and witnessed, has taken more than its fair share of housing, and I'm led to understand that we're way ahead of our current allocation. New buildings, and if granted, only at additional stress in areas such as schools, health practices, and other services. I'm not opposed to, development or better, greener things coming into the villages. But I mean, I've resided in the village most of my life, and I've seen lots of property go up, but never seen new school being built, the health practice being expanded, etc. Green space, in my opinion, is precious, and is getting less of it, especially in our area. In my opinion, and again, the Prime Minister mentioned it in his speech last week about green space and brown belt. Why pick on green space every time when there is more than brown belt available for building? And to be honest, if this gets the go ahead, then yes, it will be disappointing for people in the surrounding areas. And the other thing is, Coppull is getting less and less green space available. And I'd like to leave it at that, Madam Inspector.
Okay, thank you very much. Just one thing, just to clarify, you said at the beginning that you believe the land was safeguarded to 2026, is that right? So you have an expectation that it's likely to be built on in the short to medium term, is that correct?
No, it's not correct. Albeit that, I was told that it was 2026, but that didn't mean to say that should there be a need to build more property in the surrounding area, then it would be allocated for build, or it could be forced into being built on. But that was I was led to believe that would be a very, very long shot, especially with the other areas in Coppull that was currently being built on. If I take Mill Lane, for instance, where the two factories used to be, one factory's been knocked down. There's over 100 houses being built on that in that area. Chapel Lane, where Baron's Caravans used to be. All that area has been built on. Prior to all that, when I was a child and playing out, all these used to be play areas. There's just less of it.
Thank you very much, Mr. Winstanley. Does Mr. Cannott, do you have any questions or comments? No? All right, thank you. As we did hear from a number of local residents on our first day on Monday morning, and I know you weren't able to be here then, but I certainly am aware of the local residents' concerns and the various issues that have been raised, which I will consider in making my decision. So thank you very much, Mr. Winstanley. Thank you. Right, we're now then going to carry on with Mr. Ponter's cross-examination of Mr. Saunders, the appellant's witness. So over to you, Mr. Ponter.
Thank you, Madam. Morning, Mr. Saunders.
Morning.
We'd reached the topic of what you do about factoring in or not factoring in oversupply in the 5-year housing land calculation. So I want to turn to that next. And I'd start, please, by turning up one of the several appeal decisions that addresses this issue, and it's CD 9.10, which is a decision by Inspector Reagan dated the 19th of April of this year concerning a site known as Waters Lane, Middleton, Cheney, in the administrative area of South Northamptonshire. Now, turn within that decision letter, if you would, to paragraph 45, which appears in a section that starts at paragraph 44, headed Oversupply. See that?
Yes, I do.
And paragraph 45 effectively introduces the debate, namely whether or not we can offset oversupply against 5-year housing land supply requirement. And at paragraph 46, the inspector says that, in my view, while the PPG allows shortfalls against requirements from previous years, it is silent on whether it's possible to set them against future years, and therefore the facts of the matter need to be examined on a case-by-case basis. So, 2 propositions there. First, the PPG is silent on whether one can offset oversupply against future years. That's proposition 1. And proposition 2 is that it needs to be examined on a case-by-case basis. Presumably, you agree with both of those propositions.
Yes, I do.
Very much. So in other words, this is the way I'll put it to the inspector in my closing submissions: in the absence of policy or guidance, it falls to the decision maker as a matter of judgment to decide whether or not to set previous year's oversupply against the 5-year requirement. Do you agree with that proposition?
Yes, I do.
Thank you very much. Now, your evidence, and I'm looking again at the housing land supply proof, I think, page 13, paragraph 4.30. It's the second half of this paragraph. Your evidence suggests that the absence of policy or guidance means that the government thinks that oversupply shouldn't be taken into account in carrying out the 5-year supply assessment. Is that a fair summary of what you say there?
Yeah, there's no express support for it in any document.
And therefore, you say the government thinks you shouldn't do it.
Well, and I highlight a number of factors to supplement that position.
I'm looking at what you say in paragraph 413. You proceed on the basis that silence means that the government agrees with you.
Yes, that's my view.
And just so we're absolutely clear about that, I think at paragraph 46, page 46 rather, paragraph 6.69, 6.69, you say, I consider the express lack of policy guidance support to this approach as being fundamental to its appropriateness. So the lack of any guidance is fundamental to whether or not you should do it.
Yes, in my view, it is.
And you rely on that factor heavily, presumably, in coming to your conclusion as to the subject.
It's one of the many reasons I think I've documented.
One of the fundamental reasons, according to you.
Well, it's fundamental to agreeing which proposition to accept, isn't it?
In addition to the Middleton Cheney appeal decision, we've got several other appeal decisions in which this issue is addressed. You've no doubt familiarised yourself with all of them. Does any inspector say, agreeing with your proposition, that the lack of policy or guidance on the subject means that the government thinks you shouldn't take oversupply into account? Does any inspector say that?
I can't be certain that they specifically say that, but obviously in the judgments and the decisions that we have, primarily in
and in the area of Tewkesbury, inspectors grapple with the issue on both sides and say any restriction or deduction in future year supply would go against the government aims, and on the converse, it's accepted that as it's absent, that you could weigh that into the balance of whether you do accept over delivery into your future supply.
Yeah, that's a different point. And by the way, Tewkesbury's got decisions going in both directions,
Yeah,
as you
I
well
agree.
know.
Yeah.
Focus on my point, please. Is anywhere in any of those decision letters that grapple with this issue the proposition recorded that silencing government policy or guidance means that the government thinks oversupply shouldn't be taken into account?
No, and I believe that that's subject of the ongoing legal challenge.
All right. If that was the government view, as per your proposition, then it would have had ample opportunity to amend the PPG to reflect that view, wouldn't it?
Yes, but as my evidence is that I think that they've been quite clear in their expectations of how you factor in over delivery or under delivery, and that is using the HDT.
I'm going to come back to the HDT and its relevance in a moment or two. So, notwithstanding your proposition that silence means that the government actually thinks you shouldn't take oversupply into account, and that's fundamental to your conclusion, as you tell us. In fact, Mr. Saunders, the position is, as we stated a minute or two ago, the continuing absence of policy or guidance on this issue supports the conclusion that the government is actually content to leave it to individual decision makers to decide. That's the position, isn't it?
Yes, I agree.
Thank you. All right. Page 36 of your proof, please. Just to complete the point, at paragraph 6.20, there's reference to some comments of Mr. Justice Dove in one of the bits of Tewkesbury litigation. Needn't get into the detail of it, but you say midway through paragraph 6.20 that Mr. Justice Dove accepted, in the absence of any policy to interpret it was a matter of planning judgment as to how the decision maker treated an element of oversupply. So there appears to be, insofar as the courts have expressed a view, it's to support the proposition that we've just agreed upon.
Yeah, agreed.
You then go on to say, having noted that in this paragraph, however, as a matter of planning judgment, I do not consider that this is the correct approach because it is contrary to the national policy imperative to boost significantly the supply of housing. You see that?
I do.
That national policy imperative applies in every single local planning authority area in England, doesn't it? And has done since 2012.
Correct.
So as a result, if we were to adopt your approach, in every single local planning authority area, it would be wrong to take into account oversupply in conducting the 5-year supply calculation, wouldn't it?
No, I think that the parties are disagreeing on the amount of time that can pass. Because my case is that you can, an authority can over-deliver and it be counting towards them, their target and meeting and exceeding their target, whilst I don't accept that that goes back historically.
I don't understand that point. Just go back to your paragraph 6.20, please. Having recorded that Mr. Justice Dove agrees with us that it's all a question of planning judgment, you go on to say, however, as a matter of planning judgment, you don't think taking oversupply into account, in effect, is the correct approach because it's contrary to the national policy imperative. Do you see that?
Yeah.
The national policy imperative applies everywhere. And so if we adopt your approach, it would be wrong to factor oversupply into account everywhere, wouldn't it?
Yes, in my judgment.
Yeah. And so what judgment is there to make? What judgment is left if that's right?
Sorry, can you be more specific?
If, in effect, the rule is because of the national policy imperative to significantly boost supply, you never take into account previous years' oversupply. What judgment is there left to make?
You can use oversupply, but it has to be as part of the HDT.
No. The question is, as you well know, Mr. Saunders, is whether you deduct oversupply from the 5 years housing land requirement. We have reached the point where we agree that whether or not you do that is a question of judgment. That judgment is completely annulled if you're right in saying that the national policy imperative of significantly boosting the supply of land for housing means the answer is always no.
But I don't accept the proposition that oversupply should be, and it's my judgment.
In danger of going around in slightly diminishing circles. Point one, it's a question of judgment to be decided on a case-by-case basis. We've agreed that, I think, now several times. Point two, your proposition here is that the national policy imperative means that you never do it. It's wrong to do it. Yeah, that's what you tell us in this paragraph.
I think you can do it in respect of what the PPG allows you to do, and that's using it to essentially plug the gaps of your previous under-delivery.
No. Please don't try and divert the debate. You know what I'm asking you. The debate is whether or not you deduct it from your housing requirement for the next 5 years, as you well know. Just focus on that. Question of judgment as to whether or not you do that. Your position is the national policy imperative means that you never do it. In other words, there is no judgment to be reached, is there, on your case?
On my case, I just don't see any mitigating factors or any support for it as to why oversupply can be counted towards your future supply.
I'm going to have one more go, and I really would appreciate a direct answer to my direct question. Adopting your approach, there is no judgment to reach, is there?
I don't believe there's any support for the proposition, no.
Right. Madam, I've asked that question now several times. I'm not going to ask it again. I'll make submissions on the answers we've had.
Again. I think I understand the appellant's case, but I also understand what you're trying to
Very much.
bring out. Yeah.
Thank you. Let's turn up the completion figures that we have. We looked at, I think you looked at these, we certainly looked at these yesterday, and it's CD 6.15. CD 6.15, it's the latest 5-year supply state, dated May 21. Now, paragraph 4, as you looked at with Mr. Cannock yesterday, recalls that the housing requirement for the borough at the start of the plan period, which was April 2010, was 6,834 dwellings. Do you recall that?
Yes, I do.
And by the end of the period from 2010 to 2021, so just over 2/3 of the way through the plan period, net completions total 6,316, as we see in table 1 and in paragraph 6. Yeah. And we've got 5 years of the plan period remaining, haven't we?
We do.
And your assessment is that in that 5-year period, surely we'll see the delivery of just under 1,400 units.
Yes.
Our position is around 1,500. So whichever of those figures is used, the result will be, over the plan period, well over 7,500 dwellings, either 7.7 or 7.8. Yeah.
On the basis of the two cases, yeah.
And that, on any view, is significantly in excess of the core strategy requirement of 6,834, isn't it?
Yeah, it's probably 10 to 15% over across the 15-year period.
Yeah. And that requirement of 6,834 dwellings over the planned period for Chorley was endorsed against the policies of the 2012 framework, wasn't it?
Yeah, I believe obviously there was late additions to it through with the inspector, but yeah, I accept that it came through at that time.
And it was endorsed against the policy requirement at national level to achieve a significant boost in the supply of land for housing?
The inspector's report makes clear that that is known.
We don't need to turn it up. We looked at it yesterday. It's paragraph 49 of CD 6.19, isn't it, for the inspector's note, where that's expressly stated. Now, your evidence, having recorded, I think it's again your housing land supply proof, your evidence, having recorded where the core strategy inspector, us having noted where the core strategy inspector notes that consistency, paragraph 535 on page 22 of your proof, housing land supply proof, contains the proposition, it's the very foot of page 22, that it can be concluded that the 417 figure did not represent an MPPF compliant figure on housing needs at the time, because it was not an objective assessment of need and or did not boost significantly the supply of homes. Do you see that?
Yes, I do.
Do we cross some of that sentence out, Mr. Saunders?
I think my assessment of that was also to cross-refer to the evidence provided by the council's consultants, Iceni, in respect of Chain House Lane, which I referred to in the latter part.
Yeah. It now having been drawn to your attention what the core strategy inspector actually said, which you don't refer to either here or I think in any other part of your proof, can we cross some of that sentence out? Because it's clear that he concluded that the 417 figure would boost significantly the supply of homes in Chorley, didn't he?
I think in respect of the overall housing figure at the time, it was accepted where it was derived from and the distribution was accepted. And obviously if that was done so in with MPPF being brought through at that time, then yes, I think you could.
So that's what you tell us there is wrong, and we can record that when adopted, the figure of 417 was found to significantly boost the supply of land for housing in Chorley. We can recall that, can't we?
It was found to be a minimum annual figure that the inspector was happy to endorse and adopt the plan.
Mr. Saunders. No, he hasn't. We can record, can't we, that the 417 figure was found to significantly boost the supply of land for housing in Chorley, can't we?
Is there an express reference like to that effect in the
Do you want me to
inspector's
take
reports?
you to the core strategy inspector's report?
Yeah, just to verify that, and then I can
Well,
accept that.
I'm happy to. It's CD 6.19. You'll recall that we looked at this yesterday in re-examination with Councillor Wilson. It's paragraph 49. In the last couple of sentences of that paragraph, the inspector recalls that the provisions of the proposed housing-related changes, that's what the acronym PHRC stands for, accord with RS housing requirements and the intention of the framework to boost significantly the supply of housing. See that?
I do.
Are you now prepared to agree with my proposition?
So I'm just reading the thrust of policy for as a whole. I think as part of the overall housing requirement at the time, yes, he's clearly considered it against MPPF and is satisfied that it significantly boosts housing.
Thank you very much indeed. All right. Back to the Middleton-Cheney decision, if we may. That's CD 9.10. Paragraph 47, if you would, please. Because this is the crux of the inspector's analysis, or that inspector's analysis, Inspector Reagan on the issue. And in the third sentence third sentence, she makes the point that a failure to account for oversupply in the 5-year supply calculation would lead to an artificial inflation above the housing requirement in the adopted local plan, because, as she says in the previous sentence, those homes will already have been provided. Now, as a simple matter of fact, that's correct, isn't it?
Yes, I think that's the nub of the case to allow for oversupply, and as far as I can see across the judgments in favour of that approach.
As a simple matter of fact, that is correct, what she says there.
Well, to that, yeah, that's
Thank
correct.
you very much. And then at the top of the next page, still in paragraph 47, Inspector Reagan observes that delivery is bound to fluctuate from year to year. That too is factually correct, isn't it?
Yeah.
Albeit, as we saw yesterday in the case of Chorley, delivery has been strong in the early part of the plan period, just as anticipated by the development plan. Do you remember we looked at that yesterday? Yeah. And just looking at the converse proposition, assuming that Chorley hadn't done so well in the early part of the plan and there'd been undersupply or under-delivery, you presumably would be requiring that undersupply to be made up in the next 5 years, wouldn't you?
Well, there's two methods of doing so, as far as I'm aware, and obviously that aligns with the PPG paragraph which says that. So I would expect that could be justifiable, yeah.
And in those circumstances, putting aside what PPG might tell you to do, you wouldn't be saying in those circumstances that you should just continue to apply a flat 417 dwellings per year requirement simply because that's how policy 4 is expressed, would you?
I think each area would have to look at it on its own merits.
I'm asking you about this area.
Well,
you wouldn't be suggesting that, would you?
But that's not what we do find ourselves in here, is it?
No, I'm asking you about a hypothetical situation. You wouldn't, just on the basis of what policy 4 says, say that notwithstanding undersupply, it's 417 a year for the next 5 years, would you?
It would be I would agree with that.
Thank you very much. And the substantive reason why you wouldn't be suggesting that is because the important objective is to deliver at least the housing requirement for the plan period, isn't it? That's the important substantive objective behind all of this.
No, I think it depends how the policies are written.
Yeah, it does. That's my point.
Each area would have a different mechanism for that.
Policy 4 says, breaking it down, for Chorley it's 417 a year. We know what it says. In circumstances of undersupply, you agree it wouldn't be a requirement of 417 a year, it would be more to make up the undersupply.
I think that's justifiable against PPG, yes.
And put PPG to one side. The substantive reason for that is because the important objective is to meet the overall plan period requirement. That's the substantive point, otherwise there'd be no other purpose.
I think then we got, the problem with policy 4 here is you've got clause C as well, which obviously looks at the 3-year monitoring requirement, in which case the council may find itself foul of that if it did so.
Sir Saunders, I'm not going to fence with you. I want an answer to my proposition. Do you agree that the substantive reason why you wouldn't say it's just 417 and no more is because the important point is to meet the plan period requirement for housing? Do you agree with that or not?
In this specific situation, no, I don't actually.
You don't think it's important to meet the
I think
plan
it's
period
important,
requirement?
but I think policy 4 does make provisions as to why a shorter time frame is important to meet that minimum annualised need. And that is annualised, and then it's a 3-year period. think that's material.
I'm going to submit to the inspector when I close this case that it is important that the planned period requirement for housing is met, and that's the underlying objective. So I've got your answer that you don't think that that's important. I can make some submissions about that in respect to this
He did
debate.
say it was important,
I said
didn't
that.
he? I'm not sure he said that exactly. Would you like to repeat your answer, and then I can make a clear note, and I understand it.
I think the overall requirement of policy 4 is, of course, important. I think taking the clauses of policy 4, we have the annualised requirement, which is clearly made in part A. And then in part C, we have the monitoring requirement over a 3-year period. Now, if you're doing that, you are going to hit the requirement of the housing requirement for the policy. So I think as part of the overall, of course it is, but I think it's generally taken into consideration as part of the mechanisms in that policy. They will be achieved.
Thank you, that's helpful. So it is important, but subject to that observation about paragraph C of policy 4. Understand your point. The other related point is with regard to the local plan's position, which is at CD 6.2. And if we look at page, I think it's page 18 of that, where the trajectory is set out with regard to delivery. Page 18, it's table 1, housing trajectory. Again, we've looked at this page before. We can see that by the year 2020, 2021, that the anticipated completion level has fallen below 417. It's at 334, and then it diminishes progressively from there on in, doesn't it?
Yes, it does.
There's no suggestion that the local plan inspector who considered this local plan thought that was inconsistent with the core strategy, just because it didn't continue to deliver at least 417 every year of the plan period. No suggestion of that.
I haven't seen anything to that effect.
Thank you. And then just, I think for the last time, back to the Middleton Cheney decision, again for a point of principle. That's what I'm interested in. So that's CD 9.10. And back to paragraph 47 that we've looked at before. Continuation of that paragraph onto page 10. The inspector records that there are potential consequences of not adjusting future housing requirement to include oversupply, namely the engagement of the tilted balance and pressure for development where it's not needed. You see that?
Yeah.
Now, in this case, we know that a failure to take into account previous years' oversupply, if we're starting with the policy 4 figure, means engagement of the tilted balance, don't we?
Yeah.
And on your case, it means the release of safeguarded land for development.
Yes, it does.
And that is exactly the position adopted by the applicants in other proposals in Chorley seeking permission on safeguarded land.
Well, yeah, they've interpreted the facts of the recent decisions and made a judgment themselves on whether they should promote the land earlier.
And then if we cast our eye along to paragraph 48, the inspector recalls that the planned requirement is to meet a specific need over the planned period. To artificially inflate it through not offsetting oversupply would mean that the overall requirement figure in the plan period would increase, and the planning system which the framework makes clear should be genuinely plan-led would be significantly undermined. None of those are, if you like, South Northamptonshire specific points. They are all potentially principles or observations that apply everywhere, aren't they?
Yeah, I think you'd refer to them as general factors.
Yeah. And so they all fall to be considered in the judgment that we've agreed has to be reached in this case by our inspector.
Yes.
Thank you very much indeed. Housing delivery test. That was introduced by the 2018 revision to the framework, wasn't it?
Yes, it was.
Took effect in November of that year. This decision letter from Inspector Reagan is dated April 2021, as we know. There's no suggestion in her decision letter, is there, that the introduction of the housing delivery test means that oversupply shouldn't be offset against the 5-year requirement, is there?
No, but I'm not aware of the evidence that was presented to the inspector.
Is your proposition that the housing delivery test, in effect, deals with this oversupply issue, relied upon by any inspector in any appeal decision who's had to grapple with the issue?
I think it's relevant in that it was brought in by the government for a reason.
What's the answer to my question?
Well, I think it applies.
What's the answer to my question, Mr. Saunders? Is it relied upon or even referred to by any inspector grappling with this issue in any decision letter?
I think ACT is referred to in some of them, but I'd need to call them up and have a look. But I've presented a balance of 5 or 6 decisions in which the full cases are there.
If it is referred to and relied upon by an inspector, then no doubt it will be put to you in re-examination by Mr. Cannon. The housing delivery test exercise involves looking at the previous 3 years' worth of delivery, doesn't it?
Yes.
And then setting out a series of consequences depending upon the results of that.
Yeah.
There is nothing in the housing delivery test that considers the points addressed by this inspector in Middleton Cheney, which is focused upon the entire delivery of housing over the entire planned period. The housing delivery test has got nothing to do with reviewing that planned period performance, has it?
No.
Very much indeed. All right, planning balance, please, next. We can hopefully deal with some uncontroversial points swiftly. We agree that there's a breach of policy BNE3, don't we?
We do.
We also agree that the determination of this appeal is to be in accordance with the development plan unless there are material considerations indicating otherwise. That's a statement of well-established principle and the law. Yeah?
Yeah.
And we know that accord with the development plan is to be judged by reference to the development plan as a whole, don't we?
We do. Yeah.
Let's have a look at your planning proof for a moment, if you would. I think it's page 39, Mr. Saunders. At the top of 6.12, and I'm sure you and I are going to agree as to the approach, but I just wanted to be clear, given what you say at 6.12, which includes the statement that this demonstrates, so your assessment on the relevant planning policies in Appendix 10 demonstrates that the proposed development accords with all bar a single policy, which I consider as a typo happened, but you say generates limited policy conflict. Do you see that? Yeah. The question of compliance with the development plan as a whole isn't a numerical exercise reached by comparing the number of policies complied with against the number of policies breached, is it?
No.
And let's just turn up BNE3, please, because one of the important points about compliance with the development plan as a whole, even if it's a single policy breach, concerns the extent of the breach. Let's just have a look at the extent of the breach here. So CD 6.2. And we'll find BNE 3 at page 47. Two paragraphs of supporting text. And at 7.16, confirmation that the purpose of safeguarded land is to ensure that greenbelt boundaries are long-lasting. Paraphrased it, but that's effectively what that says, isn't it? Yeah. And we know, of course, that national policy tells us that the greenbelt has two essential characteristics: openness and permanence, don't we?
Yes.
The inspectors note that's paragraph 137 of the framework, isn't it?
Yeah, I believe so.
And then with that in mind, paragraph 7.16 goes on to say that paragraph 85 of the framework states that planning permission for the permanent development of safeguarded land will only be granted following a local plan review. Now, paragraph 85 of the framework is in effect repeated in the current revision at paragraph 143, subparagraph D, but it's to the same effect, isn't it?
Yeah.
We'll come to the terms of that in a second. Just looking at BNE 3 then, for the moment, we'll come back to paragraph 143 of the framework. Looking at BNE 3, its terms are clear that development other than that permissible in the greenbelt or open countryside won't be permitted on safeguarded land, so there's no ambiguity about its requirements, is there?
No.
Likewise, there is no ambiguity about the terms of paragraph 143, subparagraph D of the framework. Which is now where the equivalent provision to previous paragraph 85 is to be found. So that tells us in the second part of the subparagraph that planning permission for the permanent development of safeguarded land should only be granted following an update to a plan which proposes the development. So 3 points, please. Firstly, the terms of BNE 3 are consistent with the terms of up-to-date national policy, aren't they?
Yeah.
A breach of BNE 3 by permanently developing safeguarded land during the plan period would also constitute a breach of national policy.
Yeah, it would form a conflict with that.
And whilst national policy allows for the development of safeguarded land following a plan review, it doesn't allow for the grant of planning permission during a plan period, even if safeguarded land is proposed for development in an emerging plan, does it?
It doesn't say that, no, but it can happen.
It's not provided for by policy, which contains a clear prohibition against doing that.
Yeah, that's the starting point for it, yes.
And on that point, we can agree that neither you nor the council invites this inspector to attach more than limited weight to the emerging plan, which is at an early stage.
Correct.
Whilst we've got this bit of the framework open, just cast your eye down to paragraph 143E, which tells us that plans should be able to demonstrate that greenbelt boundaries will not need to be altered at the end of the plan period. You see that?
Yes.
That requirement underlines the importance of greenbelt boundaries being long-lasting, doesn't it?
Yes, it does.
It also underlines the potential importance that safeguarded land plays, because its existence might mean that greenbelt boundaries don't need to be altered at the end of the plan period. That's the point of it.
Well, I'm not going to object too vociferously about this because that does appear to be the council's case, but I'm mindful of the clear concessions made by the council on this particular point. Just asking to note that as we go through this.
Okay, that's fine, Mr. Clegg, I'm aware of that.
I'm
We'll
asking
continue.
about the interpretation of national planning policy, which ultimately is going to be there's a dispute about what it means. It's going to be a legal point for us to address you. I don't understand there is going to be a dispute about what national policy says.
Mom, you've got my point. As I say, Mr. Ponter seems intent on progressing. You've got my objection. You note the answers. I'll deal with it in closing, but I wouldn't want to.
That's fine, you can continue, Mr. Ponson.
I've got to say, man, I don't quite understand what the objection is. I'm asking about what national policy says. I literally don't understand the objection.
The objection is it's not appropriate for an advocate to advance a case inconsistent with the concessions made by his witness. And the witness has expressly conceded to me that if planning permission was granted, there would be no increased pressure on the release of the greenbelt. That is the answer that we have before the inquiry. If Mr. Wants to recast his question so that it's about the interpretation of policy, so be it.
That's how I'm asking the question. So the position we reach, Mr. Saunders, is that the appeal scheme generates a breach of the development plan, and it constitutes a breach of national policy. Do we agree that?
There's a limited conflict with the single policy development plan that we just ran through, and PPF provisions are clear, as you've just stated.
You say there's a limited conflict with the provisions of national policy.
No, I've just accepted with what you've just put to me in terms of what it says.
So there's a significant breach of national policy, is there?
Well, I think that it seeks to retain safeguarded land, but ultimately, I think then you can take it further to consider what material considerations would outweigh that. But if you're taking me to just point one of that, yes, I agree that that's what it says.
And we agree that all relevant aspects of up-to-date national policy attract significant weight.
Yes.
Where do you factor in a significant breach of national policy in the conduct of your planning balance?
Well, I weigh that into my overall consideration of the material harm of releasing the site now against waiting for it to be adopted.
You produce an awful lot of evidence, Mr. Saunders, including in respect to the planning balance. Can you take me to the bit of it where you factor in a significant breach of national policy?
Well, I've taken that under the same auspices of the conflict with BNE3.
Which bit of the proof of evidence? I assume it's your planning proof that records a significant breach of national policy. Which bit should I look at?
I haven't expressly mentioned the NPPF because, as we've just determined, BNE3 is consistent with national policy. So if you'd like to add that on, then I'll accept that.
It could make a difference to the outcome of the planning balance, couldn't it? A significant breach of up-to-date national policy.
But I think that just precludes the rest of my case as to why you would do that now, and why you would seek release of safeguarded land now.
Note your answer. Paragraph 11 of the framework includes provisions as to the engagement of the tilted balance, including where the most important policies for determining an application are out of date. Those are the familiar terms of paragraph 11D, aren't they?
Yes.
And there's no doubt that policy BNE3 is a most important policy for the determination of this appeal, is there?
That's correct.
And I think if we go back to your planning, I think it's your planning proof, you give us your position as far as that issue is concerned at paragraph 653 on page 46. You tell us there that the policy is out of date for two reasons. Firstly, because it's based on an out of date and constrained housing requirement. That's your point one, isn't it?
Yeah.
And in respect of that, of course, the council's position is that MOU 1 comprised a footnote 39 review that continues to apply and is not supplanted by the standard method figure. That's the debate we were discussing yesterday.
Yeah.
If the inspector accepts that proposition advanced by the council, then your first reason falls away, doesn't it? In other words, the policy 4 figure will have been endorsed as being sufficiently up to date.
It's still, yeah, well, it's still derived, the boundaries are still derived on that figure.
Yeah. But if the figure is found to be sufficiently up to date to be used in the 5-year supply calculation, those observations as to its source, regional strategy, so on, all fall away. It's an up-to-date figure.
And then the breach with the development plan and MPPF is more significant, yes.
I know. If the inspector agrees that the policy 4 figure remains up to date and should be used in the 5-year assessment, then your reason 1 falls away.
In that eventuality, yeah.
Thank you very much. Similarly, your reason 2, which is that we can't demonstrate a 5-year housing land supply, all determined by the debate we've just had as to whether or not it's the policy 4 figure and whether oversupply is taken into account. If we win those arguments, your second reason falls away.
Yeah, I think that was what we were saying in opening, where the council have to win both of the first 2 points.
Okay. There's no other. Those are your 2 reasons. If our case on the housing supply main issues, i.e. standard method versus policy 4 and oversupply or not, if the council succeeds on those points, then there is no other basis upon which to conclude that BNE 3 is out of date, is there?
No, and then it's consistent with 38.6, and then material considerations need to be weighed in.
Exactly right. Thank you very much indeed. Okay. And presumably, just examining that eventuality, if we get to that point, BNE 3 is not out of date, and the conventional balance applies, you would accept that both it and its breach attract significant weight, wouldn't you?
Yes, I would.
Thank you very much. Now, I'm not, just as Mr. Cannock didn't spend a lot of time on examining benefits, I don't want to do the same, but I just want to examine 1 or 2 points that you raise in your evidence and your attribution of weight with regard to benefits. Let's start with your planning proof at paragraph 822. So this is on page 68, the assessment of benefits under a flat balance of the conventional balance scenario that we've just been discussing. And you tell us that with regard to housing provision, paragraph 822, you're informed on the question of weight by the Secretary of State's conclusion in an appeal decision at a site known as Money Hill. Yeah, you see that?
Yes.
And just so we're clear, your view is that significant weight attaches to the provision of market housing in undertaking the conventional balance. So if we're right on all those housing land supply arguments, housing requirement arguments, supply arguments, then your view is still that significant weight attaches to the provision of market housing, isn't it?
It is.
And that would be against a backdrop in the level of supply of either 12.6 years, your case, or 13.8 years, our case.
Yeah, and that's why I try to present the case with both a quantitative and qualitative analysis of the supply, just to give some context to my judgment.
Yeah. Just so I'm clear about that, I note what you say about the qualitative aspect of this, but is it your position that the provision of market housing always attracts significant weight irrespective of the actual level of supply?
I don't believe so. I think it's capable of. I think you've got to assess the area.
Okay, so just in terms of the numbers, you agree with the principle that the more supply there is in an area, the less weight is likely to attach to the provision of market housing. So 5.01 years is not the same as 20 years.
Yeah, I agree with that.
And the effect is progressively less weight applies to the provision of market housing along that spectrum. In a purely quantitative terms.
In those terms, yes.
Now, the Money Hill decision, which is, I think, a site in the East Midlands, what was the level of supply in that case in which, although more than 5 years, the decision maker decided to give significant weight as a benefit to the provision of market housing? What was the level of supply in that case? You know.
No, I can call it up if you'd like to go to it.
What, the decision letter?
Yeah.
Okay.
924 is it?
924 is it? Secretary of State decision, isn't it? Can't see reference to a figure in the Secretary of State decision. And in fact, I can't see reference in the inspector's report to a figure. I think it's fair to say, Mr. Saunders, that we don't know what the level of supply was in that case, do we? My reference to the documents we have.
No, the case is just based on the fact that the council does not cite 5-year supply as a reason for refusal, a reason to withhold planning permission.
So it might have been just over 5 years worth.
Yeah, I would agree with that.
Next decision letter that you rely on in informing your view that it should be significant weight is Nantwich, your paragraph 823. Yeah.
Yeah.
5.7 to 6.6 years there, wasn't it?
Yes.
Don't need to turn up the decision letter. 5.7 to 6.6.
Yeah.
And then the last of the 3 appeal decisions on which you rely, 824, Bigsby Road, Retford, where you tell us that the inspector found that similar weight, i.e. to that in the Nantwich case presumably, should be applied to the housing benefits delivered by that scheme. Do you see that?
Yeah.
Can you recall the level of housing supply in that third decision, the Bigsby Road one? I think it's 926.
Yes, yeah.
This is, I'm familiar with this one, I'm afraid to say. Being on the wrong end of it. Paragraph 13. Paragraph 13. No, the Alderson one in Tewkesbury, we won. It's 1-1. Paragraph 13, 10.5 years.
Yeah, that's correct.
Yeah, okay. And then turn on to paragraph 109, please. This is where the inspector explains his scale for ascribing weight to benefits. You see that?
Yeah.
Paragraph 111 says that the development of up to 170 dwellings would contribute to overall housing supply and Bassett law. However, owing to the strong performance of the council in terms of housing land supply and delivery, this benefit attracts only moderate weight in this case. You see that?
Yeah, I see that. But I'd just add on that obviously my analysis about the current 5-year supply that we're proposing, I think, has issues with it, let's say.
Yeah. We agreed earlier on, didn't we? I think at the very outset of my cross-examination, seems like a long time ago, that whether it's the nearly 1,400 or around 1,500, they will all be delivered in the next 5 years, and they will all make their contribution in meeting housing need, whether it's a single dwelling on a site or whether it's a large site. They'll do the same job of meeting need, won't they?
Yeah, they'll provide housing into the marketplace, yes.
So in terms of market housing, what is your qualitative point?
In this situation, as we've assessed in the table, my housing brief, is that a majority of the houses are going to be contrary to the spatial direction of the policies for Chorley, in that they're rural centre focused. And also a lot of them are small windfall developments that we don't know necessarily what they'll provide in terms of the mix for the overall housing requirement for Chorley. So we don't know how well that is fit with the 5-year supply requirement, beyond just the number, whether the housing mix type is what the market wants and needs. And so I've attributed more weight in that eventuality, that we can only really assess the benefits of the more strategic level housing schemes, which are the allocations.
Okay.
Otherwise, if I hadn't have done that analysis, I may have ascribed it less weight.
2 points. In purely numerical terms, the 1,400 or 1,500 houses will meet that level of housing need, won't they? In purely numerical terms.
Yeah.
And in terms of mix or range, whether that be by reference to size or whatever, you don't conduct an analysis to show that those 1,400 or 1,500 dwellings won't qualitatively meet need.
No, not beyond what I've set out now.
Okay. And so just going back to the numerical point for a moment, the 3 decision letters upon which you rely, we've got Ashby de la Zouche, where we have no idea what the housing land supply number was. Yeah?
Yeah.
We have Nantwich, where it was 5.7 to 6.6 years, compared with over 12 or 13 in our case, if the inspector agrees with us. And Bigsby Road, where it is about 10, which attracted only moderate weight, not significant. Still less than what we've got here if we're right. Yeah?
Yeah.
Okay. None of that supports your attribution of significant weight to the provision of market housing, does it? Contrary to your evidence.
Not specifically in the same context, no, in terms of the number, no.
Just ask a question here. One of Mr. Ponter's questions related to progressively less weight if the supply is significantly high. Now, you agreed with that. Does that suggest that you might want to reassess your level of weight?
Well, I think this is why the quantitative and qualitative aspect was brought in my analysis was just to try and give some appreciation that the overall quantity is made up of what we, as Mr. Pontus said, what we don't know, but ultimately a lot of prior approval development, windfall development, single units, and not many of which are located in Coppull, for instance, where we know market housing is required. And so ordinarily on a numerical basis, we may have just ascribed a moderate weight to the benefit, but I felt that those factors, as I presented in page 5960, just gave a little bit more understanding as to why that could be more significant.
Thank you, Madam. And then just briefly on the issue of affordable housing, because I don't think there's very much in the way of material difference between us on this. I note that whilst we've got your page 69 open, your planning proof, you tell us that at paragraph 827, that significant weight is attached to both affordable and market housing provision. You see that?
Yeah.
And elsewhere you tell us that very significant weight attaches to the provision of affordable housing. I'm assuming your case is very significant weight, not, as you tell us here, significant weight. I assume that in your favour.
Yeah, I've turned them the same as very substantial weight.
Yeah, that isn't the term you use at 827. So,
interchange wording here. Sometimes it's substantial and sometimes it's significant. There seems to be a lack of consistency.
The overview in the table should be the correct one. I apologise for any misreferencing, which we can correct. Yeah, yes, exactly, Mum. And I think that, well, that is consistent with Mr. Tatton's view, I believe, yesterday on the affordable housing point.
And I think your case was opened on the basis that very significant weight attached to the provision of affordable housing. So I understand the position. Whether it be very significant or significant, you've heard from Councillor Wilson that it doesn't actually affect the outcome of his planning balance. Is that the same for you? Whether it be a very significant benefit or a significant benefit, presumably you say the answer is the same, do you?
I do. I do firmly believe that the characterisation of it in the context of what Mr. Tatton went through should be properly reflected. And I think the word very just seems to align with the issues we have in forward planning for affordable housing provision in the borough.
But your case is that the difference between us, which is the word very,
yeah,
is not determinative of this appeal. Good. Very briefly, two other points on benefits. Biodiversity, please. Have you got the ecology statement of common ground nearby or electronically?
Yes, I do.
I just want to be clear about this. Executed between, I think, the appellant and the Greater Manchester Ecology Unit. And on page 13, areas of agreement at paragraph 4.1, and at the fourth bullet point, it recalls that the development won't result in any material adverse effect on biodiversity and a likely net gain can be achieved. Do you see that?
Yeah.
We don't know what the degree of that likely net gain is, do we? Because we're not told anywhere.
No, there's not been a net gain assessment against the metric per se, but yeah, just to conclude the point, my proof at 740 to 746 in conjunction with Appendix 11 sets the framework as how we believe that the site's capable of making a meaningful gain. We just don't know what the outcome is yet.
I think you only, even on that basis, you only get to moderate weight, don't you, for that benefit?
I think ordinarily, yeah, much to the point on housing, possibly wouldn't have been able to take it more than a more limited fact, but because we've looked at the site, we appreciate what we're having to deal with from an ecological standpoint and the current low value of it. Our ecologists firmly believe that net gain could be achieved and working on that blank canvas, and so we to ascribe more weight to that.
Okay, but all right, against the context of not knowing what the degree of that likely net gain is.
No, I guess you'd have to caveat it that way.
And then open space, finally. I think you make the point in your planning proof, and this time it's paragraph 7.30, that up to 0.81 hectares of public open space, about 15% of the site, will be devoted to that use. Do you see that?
Yes.
Public open space use. And if we go over the page, a couple of pages in fact, 739 on page 60, you attribute significant weight to the provision of that on-site open space, don't you?
I do.
And that conclusion is reached notwithstanding the position of the council's open space officer, which is that there is a surplus of provision in the local area.
Yes, that's correct.
Surely, Mr. Saunders, whether or not there's an existing surplus of open space in the area affects the likelihood of existing residents making significant use of open space on your site. If they've got alternatives, they might not use your site.
I think it provides the context as to what Coppull has, but as we heard yesterday on Monday from some residents, existing play in the area is an issue. So that was part of the approach to the illustrative master plan, including a trail through, and also mindfully bringing in land, which is the southwest corner, where there could be natural play area brought in as well, and the linkages to the nature reserve next door to the east. So there's been a mindful look at, obviously taking it from just a position of quantifying the surplus as to how that site could actually go above and beyond to both benefit existing residents of Coppull, but also development ones.
All right. Thank you very much indeed, Mr. Saunders. Thank you, madam.
Thank you, Mr. Ponter. Just picking up on that last point about public open space. One of the points the residents were making was that the existing open space on the estate had safety issues because of the amount of traffic and vehicles on the existing roads. Parents have concerns about safety for children. So have you factored that into your consideration of weight?
Well, not that specific point. We've just looked to try and integrate as best we could with the Grange Drive estate to be able to provide a benefit that's more wide-reaching than just the localised one. And ultimately, as you'll see from the when you carry out your site visit, Mom, the way in which the site links to the reserve to the east as well means it's accessible for other areas to come into as well, by foot rather than like that. So in terms of taking any further highways assessment forward, there's not been that degree or that specificity of the impact. No.
Right, okay. And given the fact that the provision of open space is required to make this development policy compliant, does that affect the assessment of weight?
Well, we've gone above the requirement.
So it's that over provision?
It's over provision. That's why, yeah, ultimately it may be considered a developmental benefit, but we believe that that we can create a range of on-site provision, actually, not just a standardised area of quick play, but be a bit more inventive with it. We've shown that central spine through and the east-west access, as well as natural open space area, which it adds to the environment of the development. And we think that goes above just being a developmental benefit. It actually can be ascribed some benefit in the planning balance.
All right, thank you. Staying on this issue of benefits and weight, I just look at the economic benefits. Now, in your assessment, you give significant weight to construction-related economic benefits. Can you explain to me why that's the case?
Yeah, again, it comes back to the point that Mr. Pont has just run me through in terms of the quantity and quality of supply. If you look at the supply, there's not a great deal of large-scale housing development proposed within that supply. It's much more isolated or single dwelling. And we looked over the Central Lancashire Employment Skills SPD and what that requires from a condition as well. And all the training that has to go into the local area for people to join the construction profession. And by providing a site for 123 dwellings, it clearly does contribute to making sure that training can be put to good use. So that's why I've possibly ascribed it a little bit more than you would expect.
Right, on the fact that the development period is likely to be around 3 years, so this benefit is going to be short-lived, shall we say, or over a 3-year period. Does that not have implications for the weight to be attributed to that benefit?
Well, potentially, but it's on-the-job skills, isn't it, that people can then use to train up and go and use elsewhere in their careers. So it is just the isolated point of looking at this development, but then what does that provide them going forward in the area? I think that was my thinking and why I gave it a significant weight.
So are there any other economic benefits besides construction skills benefits that factor into your assessment?
Well, I then split out the occupational benefits, which would result, but in my view, they're of limited weight really to the overall planning balance. And I've set them out at page 64 in detail.
Right, so you're giving them limited weight, right. Okay, all right, thank you. A couple of other questions from me then. I think Mr. Pontus covered quite a few of them already, but can I ask a question about prematurity? Now, it's clear from Mr. Councillor Wilson's evidence that the council are not pursuing the grounds of prematurity. That was clear in terms of the framework definition of prematurity, anyway, at least. But the councillor's view was that the development, he used the words premature, whether or not that's the right phrase or not, that allowing the development now would be premature in terms of the overall local plan process. I might use the word out of step with that process rather than premature. What's your view on that point?
I think the way in which I've tried to characterise it is that ultimately the site, just because it is in the development system as a consent, doesn't change the fact it will be in that plan's requirements or deliverable supply. So I think at one point in my plan I've said actually that is the basis of positive plan making, perversely, in that actually the council have certainty on that supply. And the greenbelt, the harm to greenbelt, I don't think changes, because ultimately you've got to consider what comes through in your urban capacity exercises under the SHELA, what you haven't delivered on your existing allocations, and then safeguarded land before that was considered. Now, I don't think releasing or consenting this development now changes that cascade anyway and leads to that greenbelt harm being heightened. I note the findings. I don't think it's a core document, but it was referred to at Chainhouse Lane in South Ribble's consultant's evidence and Nick Ireland's proof, but he cross-refers to the housing supply proof, which, irrespective of the cases before you, he documents there, and Nick Ireland summarises the way in which they believe that would be how you would look anyway at almost forward planning. And that's before you look at greenbelt. So I don't think that it really changes anything by approving this scheme now in terms of undermining that plan making process. I think, as I said, I think it actually strengthens it.
Can I turn that?
Well, actually, they're not necessarily questions. It's just trying to restore some argument around what residents and councillors' concerns were early in the week that are perhaps not being clarified, particularly around, at the time of the planning application, Blainscough resided in the ward area of Chisnall, and a parish within that Chisnall ward made representations objecting to the planning application on grounds of safety to do with the single access issue, and also they cited that the design of the roundabout was flawed. And I just want that to be acknowledged, because I know keeps being some reference to Coppull. Well, actually, at the time of the application, it resided in Chisnall. And then the other thing is that we spent quite a lot of time over the last few days focusing on policy and numbers and timing. And I just want to reinforce that when I came to that planning committee back in April, my principal concern and my remaining concern is one about the access and the safety of that roundabout. And we had a resident here today that's flagged it up, and all our other residents have also raised this issue. And we're losing sight of the fact that when the county council at the 11th hour of that planning application for the committee meeting came through with recommendations to object to the plan application, and actually for the first time in years actually disclosed the accident figures. Now, the accident figures in over a 5-year period, but there'd been 3 severe accidents and 2 slight ones, but there was no reference to the number of incidents, which is another issue that perhaps should have been teased out at the time, and obviously during this exercise too. And I am disappointed that we haven't got representation here over the last few days from the Lancashire County Council, and I'm mortified that some late evidence has come through that I've never seen sight of, and it's never been communicated to me. And I'd just like to put on record that the County Council might have come and agreed areas of common ground with the appellant, but at no stage am I aware that there's been any opportunity for County Councillor, as myself, to scrutinise, to even have sight of this change of their view of the current the inquiry. We had rejection at the planning committee, and now whatever's gone on, which is appropriate to have these discussions, but there's been no democratic accountability as far as it hasn't come to a committee that I'm aware of, and it certainly hasn't been communicated to me, and I'm left with dealing with it really as soon as the evidence was flagged up on the webpage early last week. So yeah, I'm mortified. So I just don't want you to lose sight of the issues that still exist of concern to myself as a councillor and for residents. I would like to question, finally though, just a little thing which probably is going to be covered in conditions tomorrow, around the natural play area, and the reference that you just made some remark about it being a blank canvas as far as open space and the play amenity. Well, clearly on the south side, this natural play area isn't a blank canvas. It's actually of historical significance, even if that's not qualified or registered. The archaeologists from Lancashire County Council have flagged up that potentially, if there's some geophysical survey done, that there could be some burial remains there. And, I wouldn't like you to think you could just come and dig that all up without having some respect to something that's quite sacred and important to residents in the new parish of Coppull. Thanks.
Thank you very much, Councillor. Right, we're now on 11:05, so I think it's probably opportune to have a short adjournment, and then after that we'll come back for Mr. Cannick's re-examination.
Could I ask, perhaps for 20 minutes, I mean this totally respectfully, but caught me slightly off guard with some of the documents that have been submitted overnight, which I wasn't aware of. So I'd just like to try and just organise my team around those and just organise my notes for examination. So if I could ask for 20 minutes.
Well, if we say 11:30, then you've got 25. That'll be fine. Yeah, okay, we'll adjourn till 11:30 then, thank you. Yeah. Right, thank you everybody. Time is now 11:30 and we are resumed. So it's now over to Mr. Cannock for his re-examination of his witness. Thank you.
Thank you, Ma'am. Mr. Saunders, I'm going to ask my questions in re-examination in the order they were asked of you. So we'll go back to the start of yesterday afternoon. One point that was put to you by Mr. Ponter is delivery after 2026 is not going to fall off a cliff because we'll have a new local plan. And you said, yes. Right. On that premise, we have a new local plan. We know that it's currently envisaged at 2023. What land use planning harm is there if consent is granted now rather than pursuant to an allocation in 2023?
There isn't any.
Next, you were asked a question about your proof of evidence at 548, please. And I think that was your housing land supply proof at 548. And if we read the first sentence, you're talking about the radical policy reforms which represent a material change of circumstances which renders the conclusion of MOU1 as being out of date. And this has been shown to be emphatically the case in Preston and South Gribble authorities, in recent appeal decisions and High Court legal challenges. You were asked about then Cardwell Farm. I'll come on to Cardwell Farm in a moment, but I just want to look at what other decisions you're referring to there. At 546, you're referring to the decision of Mr. Justice Dove in the Wayne Holmes case, aren't you?
I am.
And you refer to an extract which says, which has to be taken on the basis of not only the salient facts of the case, but also other national and local policy considerations in reference to a planning judgment. And if we just look at CD 9.3, please. We have the decision at Chain House Lane. And can you find, please, paragraph 14? Do you have it?
I do.
And so if one finds paragraph 14, we see the inspector there referring to that High Court judgment, you see?
Yeah.
And I won't read it out, Ma'am. I'm sure you've read it or you will read it. And then over the page, paragraph 15 is acknowledging the concerns raised by Wayne Holmes in that case, that paragraph 73 in particular could not have been written with the expectation of the use of the standard method rendering reviewed policies out of date. Do you see that? That was a proposition which was put to you by Mr. Ponter. And the inspector says, I do not consider that the introduction of the standard method in itself represents a significant change in circumstances. Rather, the question is whether the outcome of applying the standard method represents a significant change if it's appropriate to apply the standard method in the first place. And if one goes on to paragraph, we'll go on to paragraph 30 because we see the denouement, the point that that inspector then relies on local housing need as the basis for the 5-year supply calculation. So just pause there, please. Your conclusion, how consistent with the conclusion of the Chain House Lane inspector having referred to the decision of Mr. Justice Dove in the Wayne Holmes litigation?
How consistent is my position?
Yeah.
Yeah, entirely consistent.
And in paragraph 28, we see this inspector dealing with the Cardwell Farm decision. So taking a step back, to which do you invite this inspector to attach greater weight?
Chain House Lane decision.
Thank you. And then in terms of Cardwell Farm, you made a point in answer to Mr. Ponter's questions that you saw that as being a decision which was looking at whether there'd been a review of a review rather than necessarily exercising a planning judgment, which you and Mr. Ponta later on in the cross-examination agreed to be the correct approach. Now, in that context, Mr. Ponta asked you a lot of questions about Cardwell Farm. Paragraph 39, he asked you about MOU2, and the point that he put was that Preston had withdrawn from MOU2. He invited you to agree, and you did agree, that MOU2 was defunct. Do you recall?
Yeah.
Right. Using his words, withdrawing, resiling, defunct. Want to look at the evidence base then that underpinned MOU2, the Iceni report, the 2020 report. Have Chorley resiled from the 2020 report of Iceni?
I've not seen anything, no.
Have Preston resiled from it, or do they continue to rely on it?
No, continues to rely on it.
And South Ribble, have they resiled from the 2020 strategy, or do they continue to rely on it?
Continues to rely on it.
And Mr. Ireland, the author, what's his current position at inquiries?
It is firmly that the local housing need is to be used.
And so has any party, so far as you're aware, resiled from the conclusion at 325 of the Iceni report?
No.
So whilst MOU2 may be defunct, what weight do you invite the inspector to attach to the Iceni report?
Full weight is consistent across the central Lancs housing market area.
You were then asked about paragraph 41, about potential inconsistencies across the HMA. So the point is, surely are planning to policy for A, Preston and South Ribble planning to local housing need. Clear. I don't think it's a potential inconsistency. I think it is an inconsistency across the HMA. And you were invited to note effectively that the inspector appeared to be content with that position. Now, let's just look, please, at CD 6.1, the Joint Core Strategy. CD 6.1, the Joint Core Strategy. If you want to tell me when you're there, because I can't see.
Yes, I'm there.
And can you find, please, paragraph 1.5?
Okay.
And what 1.5 is essentially telling us, I won't read it all out, is that the combined area, so that's the three local authority areas of South Ribble, Chorley and Preston, function as one integrated local economy and travel to work area. It's a single housing market area. Nearly 80% of house moves take place within it. It's appropriate and efficient to consider the similar issues facing South Lancashire in a collaborative way, and so better plan for the future of the area. In the light of that, how appropriate do you say it is for there to be potential or actual inconsistencies in how housing land supply is calculated?
I think it's harmful to that, and I think the inconsistency is Charlie's position is different to the other two, is highly material.
And if we just think about the aggregate approach at the moment, which is South Ribble, and I apologise if I haven't quite got these figures right, but broad strokes, South Ribble, last time I looked, I think we're planning for 190 dwellings per annum, Preston 250, and surely we know 104 dwellings per annum. As an aggregate, that inconsistent approach, what effect is that having, and how consistent is that with the imperative to boost significantly the supply?
The combined figure is, I think, approximately 550, which is roughly half of the current local housing need, which was established recently. So I just don't think that it's plausible at all to suggest that that figure would be appropriate to use for planning across the central Lancs housing market area.
So, respectfully, how appropriate is it, do you say, for this inspector to endorse inconsistencies of that manner?
It's inappropriate, I would.
And then your point that I referred to earlier, paragraph 33 of the Cardwell Farm decision letter is looking at, this is the point I think you were trying to draw Mr. Ponta's attention to, Says the implications of paragraph 31 to 33 of the framework is that it's anticipated that relevant strategies will need updating through a new local plan or a partial review of a local plan, rather than through a review of a review. And if one looks at paragraph 40, we effectively see, again, the conclusion on the point. Pulling this chain of events together, to my mind, the review of the CLCS housing requirement through MOU1 is the only footnote 37 review that's been undertaken. Not an issue there. The decision to revert to the local housing need figure after withdrawal from MOU2 did not constitute such a review, as it had not followed a robust process. You and Mr. Ponter agree that a planning judgment is required. When exercising a planning judgment, what requirement, if any, is there for a formal process of review?
I don't know where that reference is actually come from.
So to what extent do you say the Cardwell Farm Inspector is grappling with your approach and the approach apparently agreed with the councillor yesterday?
I don't believe it's as aligned as well as the Chain House Lane decision is in terms of consideration of the facts.
And just on that point, you agreed the approach to paragraph 74, you agreed the approach to footnote 39, you agreed the approach to the PPG, but you and Mr. Ponter agreed, he asked you this question, you need to exercise a planning judgment, you can depart from the policy, but you need to exercise a planning judgment, and you agreed. So what level of consistency do we have between Mr. Ponter's approach, your approach, and the decision in the second Chain House Lane decision? In terms of that requirement to exercise a planning judgment, ultimately.
I think it's the same position across the three.
Next, please. Still on Cardwell Farm. Paragraph 30. Do you recall Mr. Ponter's 4 factors? So he took you through the 4 factors in paragraph 30. Do you see those? I want to, and essentially he had a suite of questions that if we're going to exercise a planning judgment, we need to consider all factors, and these are factors. And you agreed essentially, yes, they are. It's not a closed list. Okay? I'm not asking you as to whether they're relevant or irrelevant. I want to ask you about the weight that we should be attaching to these factors in exercising our judgment. The first one, policy 1 of the core strategy, including directing housing growth to priority areas such as Cottam and the Northwest Preston strategic location, where land had been allocated to deliver significant new housing in accordance with the city deal. Pause there. What evidence, if any, do we have of any adverse impact to, for example, the Northwest Preston strategic location or delivery through the city deal, through the application of local housing need as a basis for the 5-year supply?
There isn't any, and the only the best reference I can give to that was the consideration that at Petrie Lane 2.
I'm going to come on to that in a minute, but I want your answers first. What objection is there, if any, by Preston to the application of local housing need because of harm to city deal aspirations?
There isn't any.
No, they endorse local housing need. And what, if any, house build... Well, Preston, as we know, endorsed the use of local housing need. I don't think that's controversial. What, if any, house builder objection is there from any developers involved in the Northwest Preston strategic location or any city deal areas?
There isn't any.
The next point then is the site allocations had been determined to meet the spatial pattern of development in the Central Blainscough strategy. Pause there. What evidence do we have, if any, of impact to the development of allocations?
We don't have any.
The next point is the core strategy requirement reflects high levels of containment for both travel to work and housing market areas. So we've got a single housing market area. What impact would there be to high levels of containment if the Chorley figure goes up within the HMA as a whole?
None at all.
And then the last point is policy 1 apportionment would help to address net out migration from Preston to other parts of the HMA. 2 points. What impact does the city deal and the development of, for example, the Northwest Preston strategic location have on preventing out-migration from Preston?
It will, well, it would assist.
Right. And so if there's not going to be any impact on the delivery of the Northwest Preston strategic locations, why should there be any negative impact as a result of out-migration from Preston to Chorley?
There shouldn't be any.
And you wanted to take me then to the Pear Tree Lane decision. Let's look at CD 9.1, please. And it's paragraph 29, please. And we see, I acknowledge, well, do you want to read? I think perhaps just for speed. Paragraphs 29 and 30, and then I've just got a question.
I acknowledge that the standard...
No, I mean read it to yourself, sorry, not out loud.
Yeah, I've got them.
Okay. To what extent were these precise points raised by Chorley at the Pear Tree Lane inquiry considered and addressed by the Pear Tree Lane inspector?
Yeah, the issue of reverting back to the local housing need is fully considered in that appeal.
Right, and we see, I just pick one, paragraph 30. I recognise the arguments for voting a greater proportion of future growth in and around Preston and to align with the city deal aspirations. I also note the evidence of the 2014 based projections with a higher than normal level of completions at Bruckshaw. But I'm not persuaded that applying the standard method would unduly affect the delivery of housing in Preston and South Gribble needed to support the city deal. Right. What we know, of course, is that this decision was not taken on the basis that there had been a review. But does the fact that there's been a review change that planning judgment or conclusion that there would be no impact on the city deal growth and funding model?
No.
So to what extent have these points previously been raised and addressed?
They've been considered fully.
Next, you were asked about another factor. Chorley's strong record of delivery is capable of being a material factor to supplant the use of local housing need, and you agreed with that. Again, the issue of the weight. We looked at peak delivery in 2014, and we've previously agreed that local housing need is based on the 2014 household projections, which look at 2009 to 2014 delivery, which is that same period of strong delivery. Your view, please, on how rational it is, if at all, to look at that period 2009-14 as the basis of the local housing need and use that same period as a reason not to apply local housing need. How consistent is that?
It's inconsistent.
Right, so what weight then do you attach to Chorley's strong record of delivery in the early part of the plan?
I don't attribute it much weight at all in that.
Right. You were then taken in some detail to the Central Lancashire housing strategy and looked at a number of issues which informed the manual redistribution of the local housing need figure. Do you recall?
Yeah.
I'm not going to go through those. But I just want to go back again to the Pear Tree Lane decision, paragraph 27, because we see there that the CAHS considers a range of factors to inform the future distribution of the aggregated standard method. These include the distribution of population, jobs, workforce, and affordable housing need across the sub-region, the relative affordability and urban capacity, the existing spatial strategy, etc., etc. So again, to what extent were these precise arguments put on the basis of the same document before the Pear Tree Lane inspector?
Yes, the same. And I think I've referenced the specific point in relation to affordable housing as well.
And we look at paragraph 28, the recommended distribution, and we note also in paragraph 28 it refers to the council witness that we know was in fact Mr. Ireland, who was the author of the Iceni report. Right. So we have the same document with the author giving evidence. And what then was the inspector's conclusion about the appropriateness of undertaking a manual redistribution exercise at a Section 78 appeal?
It's inappropriate. It needs to be done through the emerging local plan process.
Right. Now, I appreciate authorities might have resiled from MOU 2, but bearing in mind the substance of the point were taken in the context of the housing strategy itself, of what materiality is that change?
The study is highly material still to the use of then the local housing need going forward.
Right. And so if these points have been put, the conclusion is it's not appropriate for a Section 78 appeal. It should be looked at through an EIP. But what weight do you attach to those factors in forming a judgment as the appropriate basis for a 5-year supply calculation?
The ones that were put to me, I don't attribute significant weight at all in that.
You were then asked about the issues and options paper and a suite of questions about the local housing need as the basis for the next plan period 2021 to 2036. And the point was, there's no suggestion that the local housing need figure will be ultimately the figure in the plan for Chorley, and you agreed with that proposition. But just by way of a reality check, let's just look at NPPF paragraph 61, please. Whether you need to turn it up, I'm sure we're familiar with it. Essentially, you use local housing need unless there are exceptional circumstances. Yeah. How likely a scenario, bearing in mind the constrained availability of land that we've agreed previously outside the Greenbelt, how likely is it that Chorley's local housing need figure will be reduced to such an extent that safeguarded land will not be required?
I just cannot see that scenario at all.
And how consistent is that position with the evidence we heard from Councillor Wilson?
He seems to suggest that safeguarded land, it was highly probable that that would be required to be released.
Oversupply. You reached a position with Mr. Ponter, I don't think it's ever been contested. You set it out in your proof of evidence that in the absence of policy or guidance, it falls to be determined as a matter of judgment. In exercising that judgment, how important is it to consider the meaning and wording of policy 4 and the NPPF?
It's the starting basis really to consider the appropriateness of doing it.
Now, you got into a discussion, so it wasn't a discussion, Mr. Ponter was asking you questions and you were answering them about silence of the PPG. How aware is the Secretary of State of this oversupply issue?
They're aware, yes.
And I just want to understand why you rely on this absence of policy. What do you say the Secretary of State could and would have done, fully aware of this issue, to the PPG had the Secretary of State wanted to endorse it as an appropriate approach?
Yeah, I think paragraph 61, it would have been simple for an update to be put in there to give that context, but it's not been done to date.
You were asked questions about boosting significantly the supply, and you were asked about the EIP inspector's report into the joint core strategy. And Mr. Ponter asked you that the inspector concluded at that time that policy 4A would boost significantly the supply, and you agreed with that point. I want to just look as a matter of chronology, please. If one looks at CD 619, CD 619, which is the inspector's report, you see that it's dated the 7th of June 2012.
Yeah.
Now, what you do is, in your evidence, is you make reference to the Gallagher Estates case. Could you turn that up, CD 915? And CD 915, we see the decision of Mr. Justice Higginbottom, subsequently endorsed in the Court of Appeal, dated the 30th of April 2014. You see that?
Yeah.
And if one looks, please, at paragraph 97. Perhaps we need to look at 96. Essentially, the point was being made at paragraph 96 that you were allowed to use RSS and evidence that informed the preparation of RS in the preparation of local plans in the context of the NPPF. And what's said in paragraph 97 is that fails to acknowledge the major policy changes in relation to housing supply brought into play by the NPPF. In terms of housing strategy, unlike its predecessors, you need to consider need, demand, relevant policy factors. You focus on the fully objectively assessed need for housing, and you meet that need unless and only to the extent that other policy factors within the NPPF dictate otherwise. That too requires a balancing exercise, but that's a very different exercise from that required pre-NPPF. The change of emphasis is clearly intended to yield different results. I won't go on through paragraph 98 and 99. You can read them, I trust you're familiar with them. But how important is it to consider the conclusions of the inspector in the light of subsequent judgments in Hunston and Gallagher when one is considering the appropriateness of the methodology and whether it boosts significantly the supply of housing?
Yeah, I think that the term just got moved on in a way from when the plan was adopted in light of those judgments. And so whilst I took Mr. Ponter's point, I think it's obviously things have moved on further through those judgments now in what actually categorises as significantly boosting housing supply.
Next, please. You were asked some questions about policy 4A, and Mr. Ponter's point was the important point. Missing some words here. I'm sure it was a more elegant question than I'm going to suggest. The important point is to plan across the plan period and to meet the minimum requirement across the plan period. Yeah. If one looks at policy 4A and policy 4C, how important is it to maintain a continuous forward supply as well as meeting the requirement across the plan period?
Yeah, I think the both go hand in hand. I think the requirement is the starting point, but ultimately the policy's gone on from that to add additional points to it, which are that it expects an annual figure to be met quite explicitly, and then it has a 3-year delivery mechanism inbuilt in that.
Now, you were then asked some questions about the Middleton-Cheney decision. One of them concerns previous undersupply, and we've had that debate about the conceptual difference. But Mr. Ponter's point was that previous undersupply means that the tilted balance can be engaged. One of the council's concerns, I'm not sure whether it's still an extant concern, but one of them has been the impact on Greenbelt. Sorry, just to be clear, the point that was being made by the Middleton-Cheney inspector that Mr. Ponter was asking you about is, well, it might lead to development in unsustainable locations. Does the tilted balance apply in Greenbelt areas?
Yes.
Well, yeah, this is the buzz around. No. Let's just look. Okay. The tilted balance is expressly disapplied if you're in the Greenbelt. Yeah, so you don't have a tilted balance.
Sorry, I misunderstood. Sorry,
yeah,
I thought you meant. Sorry, yeah, misunderstanding of the question.
So if the tilted balance doesn't apply in Greenbelt areas, is there any concern that a lack of a 5-year supply is going to increase pressure on development in the Greenbelt?
No, because paragraph 11 specifically gives that context.
Right. Oh, sorry, apologise. Mr. Ponter's next point was, but your case is it will lead to pressure on safeguarded land, to which you said yes. But in this scenario, where the principle of development is otherwise acceptable, why is that objectionable, that the absence of a 5-year supply leads to release of sites which are acceptable in principle? What is the planning harm?
Another there isn't any.
You were asked some points by Mr. Ponter about where and how you addressed the conflict with policy BNE3. Can we pick up, please, your planning proof of evidence at 6.49? So page 45, 6.49, you set out their policy BNE3. Over the page at 6.52, you accept that the appeal proposals do not constitute either of these permissible development types and that there's a conflict with the provision of policy BNE3. You then look at 653 at two circumstances in which the policy is out of date. At 663, you look at the weight to be given to the most important policies. To the extent that it's suggested that you haven't fully acknowledged a conflict with BNE3 in your written proof of evidence, what's your response to that?
I thought I'd been quite detailed in respect of that matter.
Right. And the point then that was asked about 653 is, if, as a hypothetical, if policy 4A is found to be up to date, your concern in that regard falls away. And you accepted that. I just want to understand this. Outside the operation of paragraph 74 and footnote 39, which are concerned with a 5-year supply calculation, how can a review in October 2017 render an RS figure up to date in the light of a local housing need in 2018?
I don't think it can. Is where we've reviewed it. We've put it in the context that I think that whilst the review has taken place, it's then the significant change of circumstances post that.
And then a final point, Mr. Saunders, from Mr. Ponter's questions. He was asking you about the weight to be attached to the delivery of market housing in the context of you having lost on oversupply and you having lost on the basis of the housing requirement. And so you have a 12.6 and a 13.8 year supply. But even in that scenario, how relevant do you say, if at all, is the local housing need figure of 2.4 to 2.6 years? How relevant is it in assessing the weight to be attached to the benefits of market housing?
I think the benefits, as I went through with Mr. Ponter, are still attributable, attributing significant weight in both scenarios.
And how relevant, rather than getting hooked up about this 12.6 to 13.8 years, if one was to look at the 1377 to 1500 figure, how important is it to look at the actual supply in the context of the objective level of need, as well as the 12.6 and 13.8 year figure?
Well, it must be, because that's going to be the starting point of, as all parties agree, for the next plan.
And then just one point in terms of the inspector's questions. The first question, I think, was asking about walking routes to the public open space. If you pick up, please, the statement of common ground on highways. So the statement of common ground on highways, and it's paragraph 4. And what we see in paragraph 4 is that LCC confirmed the TA requiring updating with, amongst other things, 4, a review of walking routes and suggested improvements. So to what extent has the appellant looked at specifically walking routes and improvements in the area?
Yeah, we have entirely, our consultants have done that full assessment work.
Thank you, Mom. Those were my questions.
Okay, thank you very much, Mr. Cannock.
Madam, can I just make 2 observations, please? I didn't interrupt Mr. Cannock whilst he was in full flow, but just 2 points. Firstly, you recall my questions to Mr. Saunders with regard to his paragraph 6.53 of his planning proof on page 46. And you will have a note of his agreement that of the circumstances in which those points fall away. And secondly, that having fallen away, there is no other basis for concluding that BNE3 is out of date. I make that observation in light of some of the re-examination that we've just heard Mr. Saunders' answers. So that's point one. The second point is this, that I think it was put to Mr. Saunders in re-examination that I had suggested that he doesn't deal with or accept breach of BNE3. I didn't put that. No part of our case that he doesn't acknowledge that. It's clearly agreed that there's a breach of BNE3. My point, I hope it was understood at the time, that he doesn't acknowledge a significant breach of national policy. Different point. So again, you have a note of his evidence given during the course of cross-examination. I don't need to say any more about it.
Point's taken. Thank you, Mr. Ponser.
I mean, just on that first point, Ma'am, my note on 653.1 is, as I put it, we'll deal with it in submission.
Thank you.
Ma'am, can I raise the issue of the evidence from Lancashire County Council?
You can indeed. What's coming on to that?
Thank you. I think I was under a misapprehension, for which I apologise, because I hadn't actually seen the document. And I'm afraid when you said Lancashire County Council, I immediately thought highways.
Oh, right, no, it's not.
Not
highways,
education.
No, it's education. Sorry, yeah.
So, Ma'am, that was the basis on which I said I was a little surprised because there was a statement of common ground, and I thought we were having an update to the highways information, which would have caused me some surprise and concern. Having now been able to understand what it is, and I don't know if Mr. Fraser is watching or whether he's on his way, but just so that you're clear, we don't have any objection to the information coming in. I think, Ma'am, we need to hand you the additional assessment. So we'll do that now. And in fairness to Lancashire, just so that you're clear, we asked for this because there was something trailed in their evidence that said, well, if Mr. Powell is right about the walking distance, well, we'd have to recalculate it. And our point was, well, it would be helpful to recalculate it now rather than having to come back. And that's generated the 92,000 figure. And then I think that Mr. Terry has put in some additional information. We're content to deal with it, and Ma'am, we're content for you to read it between now and then so that we might make quicker progress through the roundtable. I hope that
That's
assists you.
helpful. No, I think, as I said earlier, I think at the end of the day, we'll discuss it through the roundtable. And I'm sure we'll address the points raised in that way anyway. Yes, but I'll certainly have a look at that over the lunch break. Right, we're now on 12:10. Our next items on the agenda are basically the education roundtable, so I don't think we need to proceed anything further this morning. As I said earlier on, we have Councillor Hilton, I think it is, coming at 2 o'clock as well. So we'll hear the councillor first, then go into our roundtable discussion. But I shouldn't imagine that will be too long, the councillor's address. So in that case, then we will adjourn now for lunch and we will reconvene at 2 o'clock. Right, good afternoon, everybody. The time is now 2 o'clock and our inquiry is resumed. Now, I'm going to do my normal introduction because we have some new faces around the table, or around the chamber, shall I say, this afternoon. So those other people in the room will have heard this a number of times. But for those that haven't been here before, my name is Helen Hockenhull, and I'm a Chartered Town Planner appointed by the Secretary of State to hold this inquiry. This inquiry is into an appeal made by Blainscough under Section 78 of the Town and Country Planning Act 1990 against the refusal of outline planning permission by Chorley Borough Council for the erection of 123 dwellings on land adjacent to Blainscough Hall, Blainscough Lane in Coppull. So a few little reminders before we start. Mobile phones, can we have them off or on silent, please? I presume nobody intends to record the event, and I don't think there's any press present. That's fine. Can I ask the new parties this afternoon to complete the attendance list, please? It's circulating somewhere if you haven't already seen it. Thank you. And that will help me later on. Fire evacuation procedures. Perhaps the council can just outline those for me. Right, okay, thank you very much. So that's basically all I need to say in relation to those matters. This afternoon, we've got two things to talk about. Firstly, we've got Councillor Hilton here, who has requested to speak to the inquiry. So we're going to have that first. And following that, we're going to start our roundtable discussion in relation to the education contributions. So first of all, can I invite Councillor Hilton?
Thank you, Ma'am, and thank you for allowing me the opportunity to speak today and accommodating me at this time. I have quite a demanding NHS job, and it's the only time I've been able to get away during the day for work. I'm conscious that the inquiry time is precious, therefore I don't intend to take up too much of it by repeating what's already been said by my ward colleagues and Councillor Wilson. I represent Coppull as a borough councillor, and I live in the village, and it's an area that I know well. But I'm here today to represent the views of the people that elected me, and that's what I intend to do. There have been a number of concerns raised about this planning application by the residents that I represent, and a lot of them have already been discussed, ranging from loss of green space, overdevelopment of the village, potential damage to wildlife, etc. However, there are two main concerns that I have, and I appreciate that it's already been stated, but I have good knowledge locally of this area in terms of the road access. Notwithstanding comments made by Lancashire County Council Highways, I do have some concerns about this. I don't believe any of the proposed proposals to actually improve the junction will increase the visibility at the roundabout. This is something that I go past every day on my daily commute to work. I drive past this 2 or 3 times a day quite often, and I've seen a number of near misses. I've never personally seen an accident actually happen there, but I have seen a number of near misses, particularly of people coming out to Grange Drive and looking to the right, where I believe that visibility is limited. I appreciate that there have been some accident information from LCC in a report published. However, I don't believe that this shows the amount of near misses which potentially could lead to accidents. I am mindful, though, that, Madam Inspector, that you've agreed to go and have a look at the roundabout, which I really appreciate, and I think that's great. So thank you for doing that. There've also been some concerns from residents regarding the parking on Grange Drive itself, and quite often you get residents at double parking. Sometimes this results in single file traffic, and there is a bit of a backlog up towards the roundabout. It's not often that happens, but I have seen it happen. I'm also concerned about the proposed access being directly past the children's play area. But as I say, I do take comfort in the fact that you aren't actually going out there to see it. Another concern raised to me by a number of residents, and it's one that I personally share, is a resident commented to me, well, it's going to go ahead, what's the point in even trying here, what's the point if the planning process isn't being followed? And it's a concern that I share. Under the current local plan, this area is safeguarded land, and it's not for development as yet. And residents are concerned that if we actually go ahead and build here, that it's undermining the current policies that we have in the council, and they feel that they've lost trust in the planning system. These are the residents' views that they've asked me to put across. One gentleman said to me, what's next? Are we just going to abandon Greenbelt policy and build on that? Is it going to be a free-for-all on planning? And that's certainly how the residents are feeling at the moment. So I know we've got a local plan on the horizon, but we're currently working under the current local plan at the moment. I also have some concerns that if a decision hasn't been made in the new local plan on releasing of safeguarded land, and if this application were to go ahead, it could potentially undermine and prejudice the new local plan currently being worked. And that's all I have to say. Thank you.
Okay, thank you very much, Councillor Hilton. I'm sure you're aware, I know you haven't been here, but we have heard from a number of local residents over the last few days, and also from other elected members for the area. So I am well acquainted with the concerns of local residents, which I will certainly take into account in coming to a decision. As you already mentioned, I intend to do a site visit tomorrow, probably in the afternoon, and I'll have a look at the site in more detail, but also look at the highways issues that have been raised and the roundabout access to the site. So thank you for that. Mr. Cannock, do you have any questions?
No, thank you, Ma'am. We're well aware of those concerns. Thank you.
Okay, all right. Well, thank you very much then, Mr. Hilton, Councillor Hilton. Thank you. Right, so the next area of concern we want to talk about at the inquiry relates to the education contribution. Now, before we do that, I think it's probably worth just having some introductions, because we've got some new faces here so that we all know who everybody is, and also I can make a note for my records. So if we'd like to start over here, I think. Mr. Pont, do you want to go around the whole table, then you know who everybody else is? We'll start with Mr. Pont, so you know who everybody is.
Thank you, Madam. Ian Ponter, barrister, instructed on behalf of Chorley Council.
Hi, Ben Terry, School Planning Principal, representing Lancashire County Council.
Good afternoon, ma'am. Vincent Fraser, Queen's Counsel, representing the County Council. I am instructed by the solicitor to the County Council.
No one wants to hear from me anyway.
Surely not true. I'm Don Powell. I'm representing on education matters from Alfredson York Associates.
Yeah, there we go.
Ma'am, Giles Cannock, Queen's Counsel, Counsel for the Appellant.
John Powell. It's a great view. We'll stick with that. That's absolutely fine.
Okay, anyway, a couple of points of clarification before we start, I think. First of all, in terms of documents, there have been a number of documents flying around in the last few days, very late, I might say, I think I've seen all of those. What I have before me is proofs of evidence from Mr Terry and Mr Powell. I also have at CD 4.4, I think it is, the assessment that Mr Powell has produced, which I'm sure, Mr Terry, you've seen. There is also an addendum document to Mr Powell's proof of evidence with additional
Yeah, well, I'm sorry that it's late in the day, ma'am, but in actual fact, in reality, it's as fast as it could be produced. We received Mr. Powell's addendum by an email, which I think was timed at 10:27 on Monday, which did introduce new information, which hadn't been raised before, amongst other things, suggesting that the council's methodology had not been adopted, which is not correct at all. So it was obviously important that the proper information was produced on that. And we responded to that yesterday, which I think was as quick as we could do. So I'm sorry if it's inconvenienced you, but I don't think it's through any fault of the council, if I might put it that way.
I mean, I do accept that the information from the appellant did come in very late. Some of that was appendices that were already referred to. They are public documents, a lot of those. So it was just really for my information, but I do accept there was some additional and new evidence within that. As I said, we are going to accept all that evidence. We've all seen it. It is helpful to have that, I think, for this afternoon, is to enable me to have a full picture from each side so I am able to make an informed decision. So that's in terms of documents. So I think we're all clear on the evidence that we've got before us to discuss this afternoon. Point of clarification again, I believe there is no issue from either party in terms of primary school places. So we are discussing secondary school places here. Yes, good, thank you. My other point relates to the framework and the tests for planning obligations. I'm sure most of you are aware, maybe Mr Terry may not be, but certainly within the framework, paragraph 57, it looks at the tests for obligations, 3 tests, that they are necessary to make development acceptable in planning terms, that they are directly related to development, and they are fairly and reasonably rated in scale and kind to the development. So can I clarify from the appellant, which of those 3 tests do you find in dispute? If your microphone will work, otherwise you might have to shout. Go with it.
Switch again. I would say that we think that it fails the tests of necessity and also of being directly related.
Right, I can understand why you're saying it isn't necessary, because there's this debate between whether there is any surplus places and therefore is it necessary. Directly related to the development, in what way do you find that in contention?
That point would relate to the debate about out-of-catchment pupils and whether the shortfall would be directly related to this proposed development or whether it is related to the numbers of pupils from out of county in the local schools.
Okay, so I'm starting really relating to whether or not the assessment should take into account surplus places in Wigan.
And the numbers of pupils from Wigan schools, from Wigan who are or may be in school in Lancashire.
Right, okay. Thank you. That's helpful, thank you. That's just as a background starting point. In terms of our discussion this afternoon, I want to put a little bit of structure to this. So first of all, I want to look at the methodology, what that methodology is, how it's been adopted, how it's been formulated, and the elements of that. And then I want to go on to talk about the catchment areas, which I know are our source of contention, how they are calculated, either catchment areas as crow flies or catchment areas in terms of safe walking distances. Then we'll look at the individual findings of the different assessments and what they tell us. And there are also a few other matters that I want to pick up on at the end of that as well. that have been raised in evidence. So first of all, in terms of methodology, can I turn to Mr. Terry first of all? The current methodology was adopted in September 2020, is that correct? So can you tell me what process that methodology went through in terms of adoption, please?
Yes, thank you. In terms of the September 2020 update, this was basically adopted by a submission to Cabinet, who submitted approval for the adoption and publication of the methodology on the 3rd of September 2020. Prior to that, we'd consulted, unfortunately due to some COVID pressures, we didn't consult in 2020 at all. The last update of the methodology prior to that was a formal update in 2016. As part of that, we consulted with each of the 12 Lancashire districts where we are the education authority, and obviously incorporated any feedback into that. Subsequently, the 2016 report was submitted to Cabinet and then adopted.
So, in undertaking that consultation, between the 2016 version and the 2020 version, put it that way, were there any significant changes that we need to be aware of?
Not in relation to it was more about clarifying points where we'd had challenges, so it was more about changing the narrative, the text, rather than actually changing any direction of travel. I can confirm that in terms of this case, in terms of the challenges that we're looking at, there was no material change at all.
Okay, thank you. This is a question to the council, actually. So, Mr. Ponter may or may not be able to help me here. That LCC methodology, has that been adopted by Chorley Borough Council for development management purposes, or is it included within an SPD or any other planning obligations document?
I don't know the answer to that question,
but
I'll Ms. Taylor
if you could try and find out for
Ms.
me.
Taylor sits behind me, and she may well do. So if you could leave that point with us, and once I have the answer, I'll interject and let you know.
That's fine. I'll leave that one with you then. Thank you. Okay. So, if we move on then, can you, Mr. Terry, please, can you just outline in simple terms for me the basis of that methodology? How do you work these things out?
Sure, I'll try and condense it. I think it's 28 pages in the current version, but I'll try and condense that to some reasonable format. So I think just to pick up really briefly, the assessments are based on our pupil projections. Our pupil projections are submitted to the DfE and evaluated by the DfE on an annual basis through our surplus place gap return. The pupil projections are used as part of the assessment. In addition to the pupil projections, sorry, just to give you more detail, the pupil projections take on board births, migration of pupils, inward migration. So to pick up on Mr. Powell's point, the pupil projections already have a transfer rate for pupils travelling from Wigan into Lancashire schools. That's part of our pupil projections.
Also include migration out of Lancashire into other
transfer
authorities.
rates, both inward and outward, yes. And then subsequent to that, the addition, we would look at any housing approvals subsequent to the housing land supply. So the pupil projections take on board the housing land supply projections for a 5-year period. Those housing land supplies are provided to us by the District Council. We use those as our basis for housing projections going forward. Obviously, what we do need to take into account in it is any subsequent approvals since the housing land supply was incorporated into our projections. So we have 2 stages. What do our pupil projections tell us? And then subsequent to that, what the housing approvals subsequent to the housing land supply tell us? We use that to project the number of pupils either as a surplus or a shortfall of places. In terms of understanding the impact of the development, we then apply a pupil yield. The pupil yield was calculated based on some research that was conducted across samples across the Lancashire area to identify a particular pupil yield. So in terms of if a house is built and it's a certain number of dwellings, how many pupils is it likely to accommodate? And we found some research to provide us with that. We apply a pupil yield rate against each of those dwelling numbers. So a 4-bedroom pupil yield would be 1.5 secondary school pupils or 1.38 primary school pupils. In terms of outline applications, one of the things that we don't have is dwelling information. So based on a track record of past experience, what accommodation is coming forward, we took the decision to apply a 4-bedroom yield. And what that does, it kind of gives you a worst case scenario with an understanding that when we actually get the reserve matters and the dwelling information becomes apparent, we can apply an actual bedroom yield using the actual dwelling numbers. So we asked that for outline applications, we would do a reserve matters recalculation, applying the actual dwelling mix, determining the actual pupil yield. From that, we apply a cost per place. In terms of the cost per place, we use the DFE national average cost per place as produced in their annual scorecard. There does tend to be a lag in terms of that information becoming available, but we use the latest information, and as soon as that is published on the DFE scorecard, we update that. Just to make the point, we have a localisation factor applied to that. So it's the DFE national cost at 0.97. So that's our localisation factor. All of the information in terms of how the contributions are calculated is published in the methodology. It details what's included, which schools are included within the catchment, how we identify which schools are included in the catchment, how we assess and how we apply the contribution in terms of naming infrastructure projects of where we expect the money to be committed. Probably in a nutshell, that's probably my job.
Thank you very much for that. That was a very good, succinct little summary there. Can I ask you, in your methodology, do you take account of the fact that in a development such as this, there may well be families within the area who currently go to those schools in the catchment that you identify, and they may well move into this new development, so they're already at those schools. So do you take account of those pupils in your assessments?
We don't. So we work on the assumption we can't guarantee that those are children moving within an area to another local school. We have to work on the opposite assumption. And the reason we have to work on that assumption is because of our statutory duty. Our statutory duty as dictated in the Education Act 1996 stipulates that we have to ensure that there is a Lancashire place available for every Lancashire child. So we have to work on the assumption that there could be new to area children. What I would say is that we provide certain opportunities to revise our position if the contribution is not needed. So, for example, if we reassess at reserve matters and the assessment identifies a nil contribution requirement, we would revisit that and obviously re-evaluate our position. But subsequent to that, we also apply a clawback position. And one of the things that I would say is LCC does not provide school places where they are not needed. You know, this is about, if you provide school places where they're not needed, what you actually do is you damage the other schools in the area because you're drawing pupils away and potentially creating more vulnerable schools. So I think there is a commitment to only provide schools where they are, school places where they are needed. And as part of the clawback position, we actually offer an opportunity to return the contributions if the need has not materialised at that point in time. So I would make the point that there is an opportunity, if the need's not demonstrated, the contribution's not required and it would be returned at that point in time.
Right, okay. So basically what you're saying is in your assessment, you assume that those new school pupils are all going to be coming from outside of the area. They're going to be new need, if you will. So there's no account taken of children that might already be at those schools or already in the Lancashire area.
No, in terms of where pupils are coming from, we assume that they are new to the area.
So in effect, you've got a worst case scenario.
Absolutely.
Okay. You hit on another point there about your approach in terms of trying to ensure that every child in Lancashire has the availability of a place, a school place. Now, the appellant has raised some questions, obviously, in terms of, well, in doing that, you're not properly taking account of the reality that some of those pupils may well be going outside of the county. Equally, there may be pupils from outside of the county coming into the county. So can you explain to me how that is assessed in the methodology?
Sure. I mean, it comes down to our statutory duty, and that is, you know, it's to ensure that there is a Lancashire place for everyone that requires one. I think what we can't do is to look at, well, can these places be provided in another area where we don't have the data to support that? You know, I think this would it would create risk in terms of our ability to deliver our statutory responsibilities. The reality is we don't have the data for what's available in another area in terms of their pupil projections. So we could find out information from the DFE Information Service about what's happening at the moment, but we don't have pupil projections for Wigan for 5, 10, 15 or 20 years in the future. And on that basis, how would we deliver our statutory responsibility, which is to ensure a Lancashire place for every Lancashire child that wants one?
Could you ask for that information? Excuse me. Could you ask that information, say, off Wigan or whichever authority it is?
I think the fact that Mr. Powell's probably been unsuccessful in obtaining the information himself probably is a demonstration of the availability of that information.
He's not an adjoining education authority, so he might want to talk to you and not him.
Yeah, yeah, absolutely. What I can say is that we don't. I've actually tried to access this information in preparation for this appeal, and I'm still waiting for a call back.
Right.
So the idea that we could get that information, ensure it's validated to a point where at the moment we're delivering within 1% accuracy of our projections. That's evaluated by the DFE in terms of our scorecard. So to deliver that level of accuracy, to turn applications round within the timescale for assessments and the time it takes us to do an assessment, we just wouldn't, even if we felt it was appropriate, we physically could not get that information to incorporate into our assessment.
Okay, thank you. Right, can we move on to this issue of the catchment radius and how that is calculated? And I know this is an area of debate between the two parties. So we'll start with you, Mr. Terry. If you can explain how the current methodology works and how those catchment areas are derived.
So, thank you. Very simply, when we do our assessment, we get a planning application, we approach the district council and we ask them to identify a grid reference as an east in and a north in. So what we ask is that is the centre of the development. So at that point in time, we use our mapping software, and it basically very simply identifies schools within 2 miles of the development for primary schools, and for secondary schools, it identifies schools within 3 miles of the development. And basically, it then picks up any Lancashire school within the catchment of that radius.
So that 3 miles is as the crow flies, or that is not rather than in walking distance?
No, it's as the crow flies. I mean, what I would add is that there is no requirement for us to incorporate walking distances. I think in terms of our adopted methodology, we've used the straight line distance. I think when I first picked up the methodology in 2014, we were using the straight line distance at that point in time. When it was adopted in 2016, we were using the straight line distance. And when we adopted again in 2020, we were using the straight line distance. We've never moved in that position.
Right, okay. So do you base that on any particular guidance?
So we considered, looking, it has been something that's basically our methodology is developed through challenge. And for every challenge we'll get asking us to go in one direction, we get another challenge to ask us to go in another direction. Developers have asked us about walking distances in the past, districts and schools have asked us about walking distances. I think from our point, that the difficulty is when a development's not even kind of, it's not even, they haven't brought ground, to kind of say what will be a safe walking route at that point in time on a new development. It's a hypothetical that's subject to change. And from our point of view, when we looked at that as an opportunity, we decided that actually it just didn't, we considered it. We recognised that the DFE home to school transport identifies 2 and 3 miles, and I think we've acknowledged that within our methodology. But the reality is when we considered it, we just felt that 2 and 3 miles was an appropriate distance. We consulted on that in 2016 with the districts. There was no negative feedback to that approach, and we've maintained that position.
Okay. Can I bring Mr. Powell at this point? You've been sat there quietly for a while. You have a different view to the County Council in this. So why do you consider that a safe walking route is the better approach?
If I may, can I go back on some of the points on the first point as well? Just because I've been making notes as we went through, and I noticed there are just a few things that I should flag up. First of all, the consultation that Lancashire underwent for the 2016 document. Mr. Terry very kindly clarified that was with the local district councils. That wasn't with any developers or any education planning experts able to have a say in this. There's no reason why the local district councils would particularly want to engage in the minutiae of a debate about whether it should be walking distance or not, or any other matters, including the one that you raised regarding the assumption that all pupils are from out of area, which is obviously highly unlikely to be the case because people tend to move relatively locally. Mr. Terry also said that pupil projections, they have a 1% tolerance, and that's true as far as it goes, but that's a 1% tolerance for a one-year projection. And of course, the projections used in this methodology are 5-year projections. Not that that really changes the position here at all. We're not debating the forecast numbers. Mr. Terry did identify that the duty is to educate Lancashire pupils with Lancashire places. And again, you identified the issue there, which is that there are Wigan pupils in Lancashire schools. Mr. Terry doesn't know how many there are. We asked the question, we didn't get the information. He said he didn't know. It is relevant, as we'll come back to when we look through some of the documents. So I think it's important to note those things. In terms of the catchment area, we very much go to what Lancashire methodology, which was my appendix 4, my original statements, which is CD 4.4. The Lancashire methodology on page 6 of that. Glasses off. Really need bifocals now. It lists the radius that they look at, and then these distances are based on the DFE home to school travel transport guidance. And the end of that paragraph says, and are considered reasonable walking distances for pupils of compulsory school age. Clearly, the intention there is to give effect to the DFE guidance on distance. And we would suggest that in terms of sustainable development, a school that pupils can walk to at secondary level that's what we are striving to ensure, that there are places in walking distance so that it makes more sustainable development. So we think that a walking distance methodology not only is what the DFE would expect, but also helps the sustainability arguments.
How significantly different is an assessment based on how the crow flies and an assessment based on walking distances?
Quite significantly different, because some of the schools that are within 3 miles in a straight line distance would have a safe walking route much closer to 4 miles, if not beyond. So it's a very significant difference. It goes from being 4 Lancashire schools within a 3-mile straight line distance to just 2 with a safe walking route. And one of those safe walking routes is technically a safe walking route, although it goes through a country park with unmade and unlit paths. Now that technically is still a safe walking route because it can be accompanied by a parent. I would question whether that really is a safe walking route, but we would accept for the purposes of this that there are 2 schools that are safe walking routes.
Right, okay.
Sorry, Madam Inspector, could I just come back on a
Yeah,
couple
you
of
can
points
do.
there? I think it's worth noting that when we both did the same exercise, I think there's a question about the software, and the software that we have doesn't allow us to do safe walking routes. It allows us to do straight line. But I think the fact that Mr. Powell and myself both did the same exercise and found that we had different findings. So whereas we found Southlands and Holy Cross within a 3-mile walking distance, Mr. Powell found Southlands. Now that's demonstrating that 2 people did the same exercise and came to the same outcome. So I do think it does raise us questions about how subjective that exercise would be. And I think if I can just pick up a couple of other points, there is no DFE guidance that tells us whether we have to use straight line or a safe walking distance in terms of the assessment process. And further to that, the DFE guidance actually says that local approaches are reasonable. Well, we have an adopted local approach that has been adopted by our cabinet, and we feel that that is appropriate. And just one final point, I think, just to pick up.
Right, do you have a reference to that where you said the DFE guidance says local approaches are appropriate?
Yes,
Can
I
you
do
point me
indeed.
to a
Sure.
paragraph?
Apologies. So on page 4 of the DFE guidance, securing education contributions for different developers, the final paragraph, it says, there is great value in detailed local methodologies and guidance. And then it further goes on to say, this guidance is not intended to replace local approaches.
Right. Thank you.
And just could I just add one more point? We didn't provide the information to Mr. Powell on the Wigan information about how many pupils travel, access Lancashire places. We didn't say we didn't have the information. As I mentioned earlier, we apply a transfer rate in terms of inward and outward migration. We know how many pupils are travelling into the area. We know how many pupils are travelling out to the area. What we're saying is it's not part of our pupil projections to plan on the basis of what might be available outside of Lancashire in terms of school places. Thank you.
Just as a point of clarity, we're discussing here is the 3 mile distance, the 3 mile walking distance. So you do not take account of the fact that some people won't walk, some might go on a bus, they might cycle, they might go in a car. How do you take account of that in the methodology?
Well, I mean, that's the point. It's a travel route is subjective. I think that's the point. And we genuinely did look at this as whether we could apply it. And apart from the limitations with the software, we just felt it allowed us to open to too much exposure. It's about the methodology works because it's fair and consistent, and it's published and it's transparent. And the point is that the 2 and 3 miles is applied to every assessment without fail. As soon as we start talking about what is a safe walking route and what isn't, it becomes a subjective exercise where, local people will be able to put their own view on what's a safe walking route. A developer could put a different approach on it. I think from our point of view, we just looked at the 2 opportunities in front of us, and we genuinely believe that 2 and 3 miles in terms of a straight line should be reasonable in terms of an assessment, while acknowledging that the guidance does talk about safe walking routes of 2 and 3 miles as safe walking routes. I think it's also worth acknowledging that LCC provides transport assistance for primary schools and secondary pupils beyond 2 and 3 miles to access school places.
So that could if a pupil, for example, is at a certain distance, what's the threshold for assistance for say bus travel or whatever?
I think it does vary from it. I think it's been reviewed at the moment, so I think it is predominantly around the 2 and 3 mile safe walking route, but I think there is a move away from that at the moment because of funding limitations.
Okay, Mr. Powell, do you want to come back on anything there?
Yeah, one or two things. Mr. Terry mentioned that we came up with 1 school and they came up with 2 schools, and that's a reason why the walking distance is incorrect. As I said, we took a view at one stage that the second school, Holy Cross, because it was unlit and unmade, shouldn't really be considered a safe walking route. I'm happy to accept that it is a safe walking route because it is a footpath that is available, and the guidance says accompanied where necessary by a parent.
Right, so you're prepared to accept Holy Cross as within 3 miles?
Absolutely, yes.
So in other words, there's Holy Cross in Southland within that 3 mile radius?
Absolutely.
As the crow flies. Yeah.
Absolutely right. The other point about Lancashire's methodology, I think it's very clear that it says that they take the 2 mile and 3 mile distance. These distances are based on the DFE home to school travel and transport guidance. So they're using that DFE guidance to get their distances. And then it says, and are considered reasonable walking distances for pupils of compulsory school age. So they're trying to give effect to that DFE guidance in their methodology, and then applying something different. In terms of the information about...
Carry on, Mr. Powell.
In terms of the information about Wigan, it is relevant. We've explained why it was relevant at the time, and if Mr. Terry is now telling me he does have the information but doesn't want to give it to us, I find that slightly disturbing in terms of...
I'm not sure that's what he said exactly.
Well, he says he knows the numbers of pupils that are in the schools from Wigan. We asked that question of them, and there was no answer. And they said we don't hold that information. So for me to assume that that means they don't have that information, I think is wholly reasonable. And the reason we said it was necessary is because of the very point that Lancashire's duty is to provide places for pupils in Lancashire, resident in Lancashire. If the number of Wigan pupils coming in is greater than the number of Lancashire pupils going to Wigan, we've got this Malpass decision, which has been referred to in the addendum, which is pretty clear about out of catchment, out of area pupils, and should they be included or not, and what the impact of that is. And therefore, it was a wholly relevant piece of information that we assumed they didn't have, maybe we wrongly assumed they didn't have, but would have been very useful to this debate.
Right, yeah, Mr. Terry.
Yeah, if we could just come back on that, I think what Mr. Powell hasn't mentioned is that information on the Wigan schools is part of our pupil projections. Mr. Powell's sought our pupil projections through an FOI request and has been refused those. He's then been directed to the Freedom of Information Commissioner if he wants further information. So that is the route to access that information. I think, you know, there is a route to access information if we're not prepared to provide it. And he hasn't, as far as I'm aware, he hasn't followed that route. I reiterate, the Wigan schools the number of Wigan pupils in Lancashire schools is incorporated in our pupil projections already. And in terms of the inquiry that Mr. Powell quotes, at no time within the findings of that inspector does it say that we should plan on the basis of what might be available in terms of school places out of county. It talks about pupils travelling into county, and we build that into our pupil projections. So I would say that we're in line with what's found in the Malpass inquiry.
We're going to come on to those appeal decisions later. So that's one of the other matters I want to address in a little bit more detail. But, right, okay.
Can I just come back on one point? Sorry. Mr. Terry mentions the Information Commissioner's Office and taking up their refusal on FOI matters. The lead-in time on ICO decision, getting even a case hearing, is about 12 months. So for them refusing an FOI request for information that is reasonably required to assess whether contribution is necessary and would be, of course, incredibly helpful to the appellant to see, means that actually, although we are taking over the ICO, it's not going to help us in terms of getting to the bottom of the matter for this appeal, which is why a direct request was made of Mr. Terry.
Do you accept, Mr. Powell, that the County Council's view that their statutory responsibility is to make sure that every child in Lancashire has availability of a place in a Lancashire school?
I absolutely agree that that is their duty, and that is why I'm saying that's why I'm a bit confused about Mr. Terry's point about the inward migration is included in their forecast, because that's assuming that Wigan pupils are going to continue to get places at Lancashire schools, whereas of course we're saying if this development is permitted, our pupils will be resident in Lancashire, will be close to the catchment school, will get a place. The Wigan pupils won't, but that's not Lancashire's statutory duty. And the question then is, are they...
Does that not relate to the school's admission policy, though, to an extent?
Well,
whether the Wigan pupils will actually get a place in reality?
Well, they would, because if you look at the catchment for Southlands, this development is in the catchment for Southlands, so they would get a place at Southlands. They are also close to the school, so they definitely would get a place in a Lancashire school. So Mr. Terry's point about they having inward migration in their forecasts actually goes to the heart of the Malpass decision, which says, okay, yes, you might have them in your forecasts, but they are out-of-county pupils. These in-county pupils in the future would get a place, the out-of-county pupils wouldn't. Is that your statutory duty met? Yes.
Okay, Mr. Terry, you want to respond to that?
Yeah, just in terms of the freedom of information, I think it was 3 years ago that they submitted a freedom of information request. So to suggest that it's in relation to this case is misleading. So he has had, I think, 3 years to submit it by the Information Commissioner. So to suggest that it relates to this application, I find questionable. As you point out, it will relate to the school's admission criteria into who accesses school places. The only way that Wigan schools will access Chorley places is if there is a surplus of places available. In other words, they can access those places because there are low numbers, or alternatively because of the admission criteria that a school sets. In Chorley, we do have schools predominantly that are academies. So from our point of view, they can set their own admission criteria. In terms of the pupil projections and building in that intake rate, you know, Mr. Powell makes the point that we're already accommodating Wigan pupils as though that might be at the detriment of Chorley pupils. What we're doing is using past data to project forward. That's how we do our pupil projections. We look at historically how many Wigan pupils are coming into our area, and we have to make an assumption that that demand will continue based on particular challenges, such as the admission criteria, that we cannot control. So it's about making an assumption that a certain trend will continue while acknowledging that where there aren't pressures around the admission criteria, trolley pupils will get the trolley places. Thank you.
Right, okay, thank you. Okay.
Might I just
Yeah,
raise one matter?
that's
I
fine.
wasn't quite sure. Mr. Powell took us to the relevant paragraph in the methodology about what distance is used,
Yeah.
which of course he sets out, I think, at page 11 of his original assessment in August. I wasn't quite sure whether he was saying we were not following that methodology, because I don't understand the appellant to have suggested anywhere that we don't follow the methodology, or whether he was saying that the methodology misunderstood the guidance. But can I just be clear on it? First of all, the methodology there is clearly based upon radius, and a radius is a straight, by definition, is a straight line. So it's clear, it is setting it out very clearly that it's using a straight line distance. Secondly, it is right that there's reference to the DFE guidance, but it isn't suggesting that the radius follows the DFE guidance. What it actually says is it's based upon it, and then an assessment is made, and we can see at the end of the paragraph, it's said that those distances, i.e. the straight line distances, are considered reasonable walking distances for pupils of compulsory school age. Now, it may be, ma'am, that if a lawyer had got to drafting the paragraph, they'd have chosen to draft it slightly differently. But certainly, first of all, I would ask you to accept there's no question about the council in this case not following its methodology. It has followed it. And secondly, I don't think the methodology has misunderstood what it was doing, if that was what was being suggested, so to speak. Can I just, whilst I have your attention, also raise one matter which goes back to earlier, which was about the question of adoption and consultation. My understanding, and I think I confirmed this with Mr. Terry, my understanding is that even in 2016, effectively, that was an update of the methodology. It wasn't a new methodology. So that the issues that you're really being asked to consider have been around in the methodology for even longer than 2016. And you'll see that, for example, by reference to that appeal decision in 2013, which dealt with this very point about whether we should use a straight line or a walking distance.
When was it originally brought in? How far back are we going?
2012.
2012.
2011, 2012.
2011 originally brought in, right?
Because the methodology has been considered, as again you'll have seen from Mr. Terry's statement, in a number of appeal decisions by inspectors, and it's always been followed to date.
Okay, thank you. Mr. Powell is
Sorry,
chomping at the bit again. Go on.
Sorry, just on that point, the DFE guidance for homeschool transport is dated 2014, so it postdates the 2011-12 point that was just being discussed about.
Okay, but presumably the updates to the methodology have taken that into account.
But that was the consultation point that's come on since, and since the 2014 DFE date guidance, we're talking about the 2016 adoption, and not consulting only the district councils and not going beyond.
Okay. Is there any requirements set down by DFE for you to consult on your methodology?
Sorry, can I just point out that there was already guidance in place, although there was 2014 guidance, there was guidance that predated that we previously referenced. The point is that it continues to be a 2 and 3 mile straight line distance, and that's always been the case.
Okay, yeah, the question was about any guidance in terms of consultation on your methodology. Has the DFE set anything down?
No, there's no guidance on the assessment or how it should be delivered, or what catchment to use, or in terms of what consultation to follow in terms of its adoption.
So is your approach unusual in relation to education authorities? Is it
No.
standard practice? Is there a lot of authorities?
It's standard practice, and I would say it's at a high standard in terms of the methodology.
Right, okay. All right, thank you.
I think, Mum, if I may, on that point, the appellant's point is essentially relative weight of guidance documents. And as I've understood the appellant's point, the point is made, well, what opportunity, if any, has there been for example, those who might have a reasonable interest in this methodology, such as developers, such as those who inhabit this industry, such as Mr. Powell. And I understand that it keeps getting sort of rolled back and rolled back. I mean, I don't really want to know what the consultation and adoption process was for 2011-12 if we go back. I think the essence of the point, so far as we're concerned, is what opportunity has there been, say, post the DFE Home to School Travel and Transport Guidance of July 2014, what opportunity has there been for consultation and for interested people to influence Lancashire's guidance? Now, as I understand the evidence, there was some partial consultation amongst councils in 2016, and that's it. And okay, it's then rolled on in 2020, but I think that's the nub of the point.
Right. Okay.
And it goes, I think, to your determination, which is going to have to grapple on the weight.
I don't want to
I
prolong.
take your point. Can I just turn this on its head slightly here, in that this methodology, in more or less the same form, has been around for a long time. Is the acceptance of that by developers evident in the very few number of appeals that have challenged the education contribution? Because it was something that a lot of developers thought was totally wrong. Presumably, there would have been a significant amount of appeals on this particular issue. If there are, I don't know how many planning applications there are in the county and how many applications you deal with and provide guidance on education, but presumably the numbers of those that are effectively challenged are fairly low, I would have thought. I don't know.
Yeah, I mean, basically, we've flagged those up to you that we've been involved in. We've been successful in all the appeals. We've been involved in 5 since the one in 2013, and we've been so that's 5 over that period of time. I think the fact that we are transparent in our approach has helped us with developers, because they understand that everything is kind of laid out. There is no wiggle room. There are no grey areas. Everything's black and white in terms of the process. And just to pick up again on the point that the gentleman made, there is no requirement from the DFE for us to consult with developers. And I'm sure developers would like a methodology that's much more favourable to them in terms of the contribution requirements. We have to look at our statutory duty, which is to focus on the provision of school children. From our point of view, our responsibility is to consult with local planning authorities, as we did in 2016, and as we will be doing in the next update. As I said, the only reason we didn't consult was because of unusual circumstances.
Okay, thank you. Yeah, Mr. Fraser.
I really don't want to prolong it, but on this point, I'm really responding, I think, now to Mr. Cannick. On this point about there not being consultation post the 2014 DFE document, I think, if I understood what Mr. Terry was saying, my understanding of the position is that the 2 and 3 mile safe walking distances in the 2014 document were not new, so to speak. That had been the DFE's position before. There was presumably an earlier document to the 2014 document, but that wasn't a new change in distances or something that might give rise to a reason for consulting as a result of the 2014 document.
Right, clearly there are differences of opinion here, and Mr. Cannock raised the issue of weight. So how much, presumably, I'm sure the County Council here will be saying that I should be affording full weight to their methodology and their assessment. So, Mr. Powell, how much weight should I be affording in that document, in your opinion?
In my opinion, I think, given the statement that it is considered a reasonable walking distance, I think weight needs to be given more to the DFE guidance on what that is than Lancashire's statement that we will use a radial distance. And I think, had there been consultation on that point whenever it was rewritten, I think people would have flagged that up and the debate could have been had. You asked the question about numbers of appeals. If education is the sole issue, it's very rare that the level of contribution being sought is higher than the cost of an appeal. So it's often just borne.
I take your point, yeah, okay. You'll probably tell me that some developers will just pay it anyway because it's easier and it's less costly. Yeah, okay, thank you. Right, okay. Right, I think we'll move on from that particular point. I think we've discussed that enough, so we'll move on a little bit now. Right, move on to... We'll move on a little bit to this issue of Wigan, I think, and how that's taken into account. The methodology in terms of taking account of schools, taking account of pupils outside of Lancashire catchment area. Now, you said to me that the pupil projections takes account of that. So how does it do that?
So based on past data, we identify a transfer rate in terms of inward and outward migration, and that's applied. So it's basically we use past trends to determine future projections. You know, the reality is you cannot predict what will happen in school places. This is not, you cannot apply a scientific formula that will give you the exact number. For example, we are planning potentially 5-year developments with children that aren't born yet. So to make an assumption about where children will go, where they will live and where they will access school places, that position could change within this. So for example, as popularity of school changes, as Ofsted ratings of schools change, parental preference will shift. So from our point of view, we have to use past trends to determine where we think that that will happen. And the reality is that, you know, this is, you know, it's about making assumptions on the past to determine what will happen in the future.
Right, okay. So in doing that, then your position, I presume, is that in terms of the DFE guidance, taking account of pupil migration across planning areas and local authority boundaries, your methodology achieves that?
Absolutely, yeah. In terms of both the methodology, but we also publish our pupil projection methodology as well. That's part of our planning obligations policy paper, and that actually details how we do that, and that element, the inward-outward migration, is covered in that pupil projection methodology.
Do you have any comment on that, Mr. Powell?
Only to say that if at the moment there are surplus places, as an example, and pupils are coming in from Wigan, and say, let's, for the ease of numbers, just say there are 10% of pupils coming in from Wigan to these schools. That is the trend. If you roll that forward to a point where the schools are full, there will still be an assumption that 10% of the pupils will be coming from Wigan in the population forecasts. What we're saying is that actually Lancashire's duty is for Lancashire pupils, as per the Malpass decision. So we're saying that would then take account of pupils who they don't have to provide a place for. The pupils on our development would get a place, and the Malpass decision is entirely appropriate and applicable here.
Sorry, Madam Inspector, if I could just come back on that. I think the point is, it goes back to this admission criteria that the school set. Parental preference and admission criteria dictates where pupils will access school places. We have to recognise that that's a limitation. That's something that we cannot do anything about. We cannot change the admission criteria for academies. So it's about using the data to acknowledge that that is a trend that's happening. That does not mean that we plan on the basis of delivering school places for Wigan pupils. It's about acknowledging that there is a past trend of Wigan pupils accessing Lancashire school places.
Okay, thank you. Can I turn to paragraph 3.2.6 in your statement, Mr. Terry? And it might be just the way I've read it, but it appears contradictory to me. But it is based on this issue of migration. It's paragraph 3.2.6. I don't think there's any page numbers on this one I've got. It starts, LCC acknowledge that the DFE guidance, securing developer contributions for education, advises that an understanding of pupil migration across planning areas and local authority boundaries is required. And then you tell me that this is taken into account in the methodology as part of the take-up rate in Lancashire schools. Then you go on to say that inclusion of non-Lancashire schools would not be in line with LCC's statutory responsibility, providing a Lancashire place for every Lancashire child. But surely that is effectively what you are doing, that you are taking account. You see what I mean? Yeah. Possibly.
Yeah, I think in terms of 3.2.6, I think the point is 2 points. Basically, the first point is to acknowledge what you just picked up on. There is a requirement to acknowledge migration. So the first point is refers to take-up or transfer rate in terms of that migration. But then the second point on that is that we have no requirement to include non-Lancashire schools within our assessment. So whereas the pupil projection methodology identify what's already happening at the moment, that doesn't move then immediately translate to say that we should therefore include Wigan schools within our assessment, which again goes back to our statutory responsibility.
Right, okay, thank you. Anything further on those points, Mr Powell, or am I okay to move on? We're coming, well, what I want to do is look at the actual 3 mile radius and the schools that are within it.
I would just say that, as a reductio ad absurdum, if the Wigan School, if this development were right on the border, and it's not far from it, if the Wigan School were just the other side of the border, parents wouldn't care that it's in Wigan. It would be the nearest school. So to say that we would then ignore it in this assessment as not being relevant, clearly it's relevant. Parents would choose it. Parents don't draw a distinction between a Lancashire school and a Wigan school. They just draw a distinction between the school that they want to send their children to. And parental preference is it's an expression of parental preference. They don't have a right to choose a place. So if there are pupils in Lancashire who are nearer the school, and the school has radial distance as part of its catchment, which Southlands does, and this is in the catchment of Southlands and Wigan isn't, any Wigan pupil applying would not get a place above a Lancashire pupil on this development. So the fact that there are Wigan pupils in the forecast, like I say, goes to the Malpass decision.
Right, okay. The difficulties, of course, as Mr Terry said, a lot of it's parental choice. If you buy a house and you're very close to a boundary, that parent will want to go to whichever school has the best Ofsted report.
Yes.
They feel is the best school for their
Absolutely.
child.
There is parental choice.
You can't take account of that in a methodology because it's subjective, isn't it, for that particular parent?
And it will change.
Yes.
But that's why we're saying that this is the reason why we're looking at decisions that have been made about what is appropriate. And Lancashire's duty is to educate Lancashire pupils. We completely accept that. It's not their duty to educate Wigan pupils. Wigan pupils are in their forecasts. Wigan pupils, it's not their duty to educate. There are places for Lancashire pupils if there were more Lancashire pupils. So yeah, parental choice is actually a myth. There is no right to a parental choice. You're allowed to express a preference for a school, but you don't have the right to have that place. So I could express a preference. I live in Henley-on-Thames. I could express a preference for the Lancashire school, but I know I'd have absolutely no chance of getting into it. So preference has to be tempered by reality as well.
Can I just respond on a couple of points? The first one is we're measured on parental preference as one of our key metrics.
Measured by whom?
By the DFE in terms of performance. So in terms of first preferences, of second preferences, of pupils being offered places that they haven't expressed a preference, we're measured on those. But I think the other thing is, the point that Mr Powell made is right. A parent won't see a boundary if they live on a development, they will look for the best school. But Mr Powell is suggesting that distance is the priority admission criteria. And some of these academies will not have distance as their admission criteria. So we cannot develop a methodology based on what schools' admission criteria might be in the future. And I think this is the challenge that we have in terms of finding a methodology that suits everyone.
Right, okay, thank you. Right. Can I move on then to some of the findings of the various assessments? If we look first of all to Mr Terry's assessment in terms of their current methodology applying a distance as crow flies. Now there is some debate between the two parties about which schools should be included within that assessment, whether or not there should be Lancashire schools or whether there should be inclusion for Wigan schools that are within the catchment. I appreciate that. Mr Terry, can you just take me through your assessment and your position, please?
Yes, we've assessed primary and secondary the development for their review to matters. About nil primary claim for contribution requirement and a secondary contribution requirement of 18 places calculated based on the DFE's national average cost per place at a price of 21,061.75, providing
in doing that assessment, you look at 4 schools, yes? So you looked at Southlands, Holy Cross, Albany Academy and Parklands Academy.
Yes, they were the 4 schools within a straight line distance of the grid reference point provided by the district.
So you looked at those 4 in the catchment area. You then assessed how many are currently on roll, the future plan net capacity for those schools, the projected pupil numbers in January 26, then come to a conclusion on whether or not there'll be surplus places. Okay, so Mr. Powell, can I turn to you? What's your assessment of that?
I would say that that is, if Lancashire ignore Wigan schools and use a 3-mile straight line distance, that is the right assessment.
Okay, that's applying the crowful eyes.
If you think that none of the points we've made are relevant,
well,
we would accept that.
We haven't come to there yet, but yes, assuming we're going down the line of the crowful eye catchment, so you bring in 2 Wigan schools within your assessment.
Which are within, if you wanted to look at a 3-mile radius, then there are 2 Wigan schools that would be included within that 2-mile within that 3-mile radius. Yes.
Right. Okay. And those schools, how have you assessed those schools? What information have you based that assessment on? We already had this debate about the lack of availability of information for Wigan schools.
So Wigan schools information has been taken from the 2019 schools capacity return. There wasn't one submitted in 2020 due to the pandemic, and the 2021 submission, I'm sure Mr. Terry will correct me if I'm wrong, would have been made in July of this year and still be being processed by the Department for Education. I got that right. Excellent.
Okay. So what's your conclusion then, if you take into account those 2 Wigan schools?
If you take into account the 2 Wigan schools, there are 62 surplus places available in Wigan, and it then becomes a matter of what account you take of Wigan pupils being in Lancashire schools and Malpass.
Okay. Well,
Sorry, Madam Inspector, we dispute those figures, I'm afraid.
I know you do.
Just to further complicate matters.
I know you do. The information that's based on, I do appreciate you've had problems getting the information for Wigan, which does mean that your assessment, we can only take it in terms of the information that you've got. That's based on 2-year-old information. And I appreciate there was no gap return in 2020 and 2021 hasn't been published yet.
Correct. What I would say is that the information we've got from Wigan is taken from a single year and a specific data return. I know that Mr. Terry's information that was provided last night, unfortunately I don't have a hard copy of it, but I'm going on memory, refers to a lower school capacity and against the same 2019 forecast. I would imagine that if that is the case and the schools have reduced capacity, that has to be by taking out buildings of some description. Now that can either be a choice to mothball and can be reintroduced or not. But if Wigan have accepted that, then there may well have been a change in the Wigan forecast, which we don't have. So I've gone with a year that we do know the forecast for and do know the capacities of the school and used that information.
Right. Okay. Yeah, Mr. Terry.
Sorry, ma'am. Just before Mr. Terry chips in, I have to say, if I had been cross-examining, this is something I would be cross-examining on. Can I just take you to Mr. Powell's original assessment in August 2021 and start?
So which documents are you referring to?
That's his education impact assessment of the 4th of August 2021.
Yeah.
And I think it's page 9. If I take you to page 9 first of all, ma'am. That, as I understand it, the table that you see there, as I understand it, is setting out what the position is currently, so to speak. So it's not, because you can be confused if you look at these things and not understand what they're looking at. That's looking at whether there is capacity now, not at whether there is capacity in 5 years' time.
I was going to come on to this actually, Mr. Razor, but we can move on to it now if you like.
No. If you then turn over the page to page 10, ma'am, in actual fact, if you look at what Mr. Powell himself was saying originally, he was saying that there was a forecast, this is in 3.6.2, there was a forecast requirement of 2191 for the Wigan schools. And that is set against a capacity of 2140, because if you go back to that table before, you can see the capacity is 2140. So Mr. Powell's own evidence initially showed in actual fact that there wasn't any capacity in the Wigan schools in 5 years' time. Now, he's now come forward with a different figure, which he says, it seems to say comes from the same source. But in actual fact, of course, as Mr. Terry confirmed in his statement yesterday, if you look at the source, the capacity figure is 2140, as could be seen from Mr. Powell's original document.
I'm glad you raised this, Mr. Fraser, because it was something I was going to pick up with Mr. Powell on this particular assessment and how you've arrived at your figures.
Those figures are taken
So-
from the DFE website, which was the most up-to-date figure. So that's the January 2021 figures.
Yeah, so if you need to take me through this in
Yeah.
detail, because I think that will
Absolutely.
help me understand your calculation, and maybe pick up the point that Mr. Fraser's making in terms of it.
It's absolutely, and the explanation is quite straightforward
I'm
when
sure
you
it
get to
is. So if we look at 3.5.1, the table there, I think that's fairly straightforward, actually, that table. That is just looking at the 6 schools that you're assessing,
Yep.
including Standish and Jevington in Wigan.
Yep.
That then has a column, a net capacity, the PAN number,
Mhm.
the total at the bottom, which is 6,037. The number in brackets, is that sixth form numbers, is it?
That's the published admission number. That's the number of pupils they must admit if there are sufficient applicants in each year group at year 7.
Ah, right, okay.
So
right.
it should be in an 11 to 16 school, it would be 1/5 of the capacity, or it should be 1/5 of the capacity.
Right, so that's the entry at year
It's
7.
a sense check.
Okay, right, I understand that. And then you've got the NOR figure, the number on roll figure, for each of those schools. And that leads you to an assessment of surplus spaces, which you add them all up, tot it up at the bottom, you have a figure of 336.
Correct.
That's fine, I think, as far as it goes.
Yep.
And that's based at January 21 figures.
Correct. So
Then what you need to do is forecast future potential demand for pupil places. And that leads us on to your section 3.6. Now, what you don't do in here is give me another table, a comparable table with those figures in, with an extra column to come up with a figure of your assessment of the number of places would then be surplus.
correct.
Or would there be a
I don't.
shortfall? And that, I think, is where the difficulty lies for me and maybe for Mr. Fraser. But
Okay,
if
let
you
me-
can take us through it,
Of
and
course
then
I
we
can,
might be able
yeah,
to work this
absolutely.
out.
As you note, 3.5 is based on January 2021 data. I have forecasts from Lancashire because that's in their assessment of the site. They provided the forecast data for their 4 schools. What I don't have is forecast data for Wigan from 2021. So my 3.6 and 3.6.2 is clear. The most up-to-date public domain information for Wigan Council comes from the 2019 schools capacity return to the DFE. This shows a forecast for the 2 relevant schools at 2191. What I've used to compare that to is the 2019.
So that 2191 figure
Yeah.
is what exactly?
That's the forecast for the 2 schools in Wigan that are within this catchment, because they form their very own school place planning area, Shevington Standish secondary
Right,
school planning
okay.
area. So I've got those forecasts from the
Right.
2019 from Wigan Council. The discrepancy is the fact that 2019 is a different base year, so we've used a 2019 base capacity for that as well, and that is was appended to my addendum. It's the very last spreadsheet that I appended to that, which was taken from that school places return from Wigan Council, which, as of 2019, there were 2,253 places against that forecast for 25-26 of 2191, i.e. 62 surplus places. If the capacity has reduced since then, it would be surprising if that were not to reflect a fall in the forecasts as well, because it would be saying, here's a planning area, we're reducing the number of places available to below what we're forecasting we're going to need. That would be very surprising and a very unusual behaviour. So because we can't compare like with like, I've gone back to the 1 year where we can.
Right. Okay. So there's a comment there you must be put in 3.6.3, which to an extent casts doubt on some of the figures you're getting from Wigan, in that it's questioning the actual NOR numbers, and there is some discrepancy there.
Yeah, looking at that 2019 forecast, what we've then looked at is what they forecast in 2019 compared to the roll figures that they had actually on roll in 2020 and 2021, and we found that their 2019 forecasts were significant overestimates. So we have then said, if that overestimate continued, what would that actually mean in terms of number on roll in 2025-26? And it would be lower again. It would be 2127. Using just making an assumption that that overestimation percentage continued at the same rate.
So what difference would that make to your calculation?
Well, that would mean there'd be more surplus places in Wigan, even against the reduced capacity that we're now seeing, and that may be one of the reasons why a reduction in capacity in that school place planning area has been accepted.
Yeah. Okay, Mr. Terry, what's your assessment of this?
Apologies. A couple of things. The first one is to acknowledge the difficulties that Mr. Powell's clearly had in getting the data from Wigan. I would make the point we have no more success in getting data for other county or education
There's parity
authorities.
between you in that sense.
Absolutely. I think we share that difficulty, but that is the point that I would make. On what methodology should we calculate how we deliver and how we claim contributions based on 2-year data that Mr. Powell acknowledges himself was not particularly accurate at the time?
It's the best we've got is basically what we're saying, isn't it?
Yeah, but basically, how would we plan on that basis and still maintain the level of accuracy and success that we have in making sure that the level of provision is as it should be? But I think the other point that I would make is Mr. Powell has drawn your attention to the fact that there are 2 schools within that Wigan planning area. What he hasn't mentioned is if there was only 1 school within a 3-mile straight line, he wouldn't have been able to tell you what the figures are because he hasn't got school by school information, and neither would us. Neither would we. So if I can give you a scenario, if only 1 of those schools was picked up within our radius, we wouldn't have the pupil projections even for 2019, because by Mr. Powell's own evidence, he only has the area figures, not the school by school figures. So if LCC can only get that same information 2 years out of date, we would not have been able to assess it on an individual school. Now, how do you write a methodology to take that into account? The point is that I think I just want to make it clear the difficulty that we'd have in applying such an approach in terms of, in terms of accessing data. I can clearly say that the information that would be required would not be readily available in an up-to-date form, because I know if Lancashire received those requests, we wouldn't have the capacity to deal with them. Thank you.
Okay. So in terms of the assessment that Mr. Powell's put forward there, he's suggesting 62 surplus places if we take account of those 2 Wigan schools. So even taking account of the fact that there's this evidence that the data is based on an area basis rather than individual school data, what is your view on the accuracy of that information and what weight I should give to it?
Thank you. Just to pick up on one thing, the DFE information that Mr. Powell quotes, I went on that information source last night, and it confirms the figures as Mr. Powell had originally submitted them in the proof of the 4th of August, not the figures that he submitted yesterday. So just to confirm what those figures are, that is a 890 for Shevington and a 1250 for Standish. They're the schools, that is the data published by the DFE on there. It's called GIOS, Get Info Online Service. That was on their website last night. It's a replacement of EduBase, which is basically we've always used as our latest DFE information. So
and those figures are numbers on roll.
That's the capacity of the schools. So what we're saying is that actually the capacity of those schools, as based on the DFE numbers, is 2140, and not the higher number as the lower number as Mr. Powell projects. I think, you know, I mean, basically in terms of those numbers, we have to use the DFE figures as provided. So what that's actually showing is that when we take that into account, we've got a demand of 2191 against a capacity of 2140. Now, that tells me that there's a shortfall in those Wigan schools projected to be 51 places in 5 years. That's using Mr. Powell's data and the DFE capacity information.
Mr. Powell, I'm sure you want to come back on that.
I would like to come back on that, yes. And Mr. Terry's right that the 2021 data for these schools on capacities does say 2140. And I go back to the point that we've used the base data from the same year as the forecasts because they will have changed. The forecast will have changed to reflect these matters as well. So we have used the base date from the same year. So we've said 2253 and 2191 was the forecast. Like I say, the forecast proved to be overestimates for the forthcoming years from Wigan. So one would assume that by 2025-26, that would only have been exacerbated. So to then pick that as the forecast to compare with the 2021 capacity is possibly a little disingenuous, I would suggest. I think we've used the same base date for consistency's sake.
I think it would be questionable to say that we should use out-of-date data in an education contribution assessment when we know that there's more up-to-date information available, particularly in relation to the tests of SIL.
Okay.
Can I just comment on that too, ma'am?
Yeah.
I understand the difficulty that Mr. Powell faces with the information that he has, but he is actually asking you, and is indeed making an assumption that the reason why the latest figures on capacity show a capacity of just over 100 less than the earlier figures is because there's reduced demand. We don't know that at all. It could, for example, simply be because the first figures, the earlier figures, were erroneous and you now have the correct figure. So he is asking you really to make an heroic assumption, which merely illustrates why we shouldn't be trying to take into account any of the Wigan information at all, because once we do start looking at it, it rather forcefully makes the point that it's just not reliable.
Okay, thank you.
Mom, just on that point, I always like Mr. Fraser's term phrase, heroic assumptions, very often evidential leaps of faith. I've made a note of them in the course of my fledgling career. I think it's important to just bear in mind, of course, your starting point, which is paragraph 57A and B. And what we're debating actually at this stage of the inquiry is the reasonableness of the use that Mr. Powell has made of information which is not his, which he can't access, and which a public body is not supplying him. And we can make submissions about whether it's appropriate to compare the base date with the base date or a base date with a different base date. And we'll make submissions on that in your form of view. But fundamentally, what one needs to just bear in mind is this is the local planning authority, actually, not Lancashire County Council. This is the local planning authority making the case that it's necessary. They're relying on Lancashire County Council information. And we're saying, well, hang on a minute. There are other factors at play here. Please, can we have that information, Lancashire? It hasn't been forthcoming for whatever reason. Wigan, can we have that information? No. And it may be a heroic assumption based on an absence of information, but if you follow the logic of Mr. Fraser's colourful submission, it doesn't lead to the conclusion that it's necessary. It leads to the conclusion that the local planning authority need further information before they can demonstrate that the SIL tests are met.
Okay, all right, point taken, thank you. Right, what should we move on to now? We looked at that. Okay. Shall we have a look now at your alternative assessment, Mr. Terry, which arrived, well, with me, it only arrived today, apparently. Unfortunately, I haven't got a copy of it, so I only got it just before lunch to have a look at. This looks at a suggested partial contribution based on slightly different assumptions in terms of looking at the 3-mile walking distance as opposed to the 3-mile catchment radius. So do you want to just take me through that briefly?
I would like to point out that this is a hypothetical assessment
Yes, I appreciate
requested by
that.
Mr Powell. This is not following
I
the
appreciate it
education.
doesn't follow your methodology.
Absolutely.
And it's just for my information so that it's something I can have a
Yes,
look at. If I make the decision that your methodology is incorrect and we should be going down this alternative route, but I appreciate that. Yeah.
Thank you.
Caveats accepted. Yeah.
Thank you. Yes, so based on so obviously, as mentioned earlier, Mr Powell had identified one school within one Lancashire school within a safe walking distance of the development. We'd identified 2 schools. Mr Powell then approached us and asked us to produce an assessment based on the 2 schools as LCC had identified schools within a safe walking distance, and that was Southlands and Holy Cross. So following the same process as that identified earlier, the assessment taking into account pupil projections, housing approval subsequent to the housing land supply, and applying a 4-place bedroom yield, we identified a place requirement of 4 secondary school places, and that equated to a contribution of just over £92,000.
Okay, Mr Powell. What's your view on this alternative assessment?
I'm perfectly content with it. I don't obviously have the details of the subsequent applications that Mr Terry refers to in front of me, but I'm happy to accept that reduces the available capacity and that we would need to fund 4 places, and we would be happy to put that in. I think it's there in the section 106 should you decide that is the relevant clause.
Yeah, well, we'll look at that on around 106, but yeah. So effectively, you're content with that methodology and that assessment if I consider that to be appropriate?
Yes, if you consider that the Wigan School should still not be in there, then I would be content with that assessment of the walking distance. Assessment of the site.
Okay, thank you. We have a little bit more to do. We've been talking away here for an hour and a half, so I think it might be worth us having a very short little break. Can we say 1/4 of an hour? So we'll come back at 3:45. Thank you, everybody. Right, thank you very much, everybody. The time is now 4:45, and we are resumed. Before I move on to what I might class as other matters, which really relates to some of the additional information that's been provided by the appellant earlier on this week, are there any further comments from either party in relation to what we were discussing before the break? We're all content with that. Right, okay, that's good.
Madam, I can give you an answer to your question
excellent.
that
Right.
you asked at the outset of the session in the afternoon. Chorley hasn't formally adopted the county's education methodology. I'm not sure that there would be any reason for it to do that because it's the county's internal process in effect. In terms of the policy basis for seeking education contributions, policy 14 of the core strategy. Education needs generated by development to be met by a contribution.
Right, no, that's fine, that's helpful. The reason I asked that question is that some authorities have applying obligations SPD, which they formulate and adopt themselves, which may make reference to the County Council's education methodology. But I wasn't sure whether Chorley had done that or not. That's fine, no, that's helpful, thank you for that. Can I have a look now at this Malpas appeal decision that Mr. Powell made reference to a number of times before? So, if we have a look at that. Perhaps, Mr. Powell, you can lead on this and just explain to me which paragraphs to look at and explain to me why these are important for your case.
Sorry. Thank you, John. Page 9, paragraphs 50 to 52. The position in Malpas was there's a high school in the Cheshire West and Chester area, which was full. It was full on the basis that a significant number of out-of-area pupils from Wrexham and Shropshire were coming into the school. And whilst the determination that the no education contribution was made on money to spend anyway, the inspector looked at this matter. On that basis alone, no contribution should have been requested because the duty is to educate, in this case, Chester pupils, educate the Wrexham and Shropshire. At the end of paragraph 51 is pretty clear. Have the opportunity to children. There is no reason why that should be so in planning terms. So it wasn't in planning terms that a contribution be made because of the numbers of out of catchment, out of county pupils that were attending that school.
Okay, thank you. But as you say, in this particular case, improvements to that school had already been formulated and were being funded anyway. So that would have been presumably part of the inspector's overall conclusion.
Debate that there was no issue because there was going to be an expansion of the school greater than the number of pupils generated. But they did also say that there is no reason in planning terms because of these out of catchment pupils that a contribution would have been necessary.
Do we know anything about the methodology that is used in this particular case? Whether that is similar to Lancashire County Council or?
It's very similar. The radial distance was somewhat less important there as to whether it was radial or straight line distance because within Malpas there was only the one school within that 3-mile radius or straight line distance because of where Malpas sits. That Malpas decision has also been referred to and used in other decisions rather than providing a raft of those. I left it with the original one, which was the Malpass one, but it's been used in Knaresborough, in North Yorkshire, in Tetsworth in Oxfordshire, and in Audlam, which is, I think, Cheshire East.
Yeah. So, if this authority is also using a 3 mile radius, is that a 3 mile as the crow flies, or safe walking distance?
There would have been no difference, so it wasn't a matter that was
Didn't
raised.
matter in that case because it's a very rural area, effectively.
Exactly.
So there's only one school within.
There's only one school serving
Anyway,
Malpass,
right,
yeah.
okay. Mr. Terry, what's your view on this decision?
I mean, on that, in this circumstance,
Yeah.
in this case, we would agree with that. And equates to a challenge to our methodology in relation to whether we should accommodate Wigan Wigan schools within our assessment. I think there's a leap being made there.
I think it's also difficult actually because looking at the inspector's decision letter, what he refers to simply is the catchment area of the school, effectively. Even though there's an efforts to a large number of those from that's also being from Coppull authority, but it's not clear in reality that he is addressing this issue at all about whether it's appropriate to look for people or to deal with people in another county, either by looking at the number of schools coming from that county or looking at the schools in the from further afield. The school's admission policy gives preference for those who are closer. As development will be closer, therefore they will beat those ones from further afield under the school's own admission policy. Development to make a provision because the pupils will inevitably, because of the school's own admission policy, be accommodated. That's not dealing with this type of situation at all, I might say so with respect.
Mr. Cowell?
I think it's exactly the same position in that these pupils will be living in the Southlands catchment area and would get a place in Southlands school. If we want to look at it on a catchment area basis, I think it's very clear that the numbers of out of authority pupils was a relevant factor. The line before I quoted in this says the contribution's aim of achieving the permanent increase in capacity for what is not going to be a permanent issue is therefore not justified. The reason it wasn't a permanent issue is that in future these pupils would get a place, other pupils from further afield would not. They were in Wrexham and Shropshire and then had a duty to be educated. And that is exactly the same position we have here with the Wigan pupils that are coming into the authority, although we don't have a quantifiable number because that hasn't been provided to us.
Right, okay. All right, thank you. That's something for me to consider further. Mr. Terry, you also provide a little bundle of appeal decisions, which in general terms, your statement really refers to the fact that the County Council's methodology has been upheld at appeal on a number of occasions. Is there anything in particular in any of those appeal decisions that you want me to make reference to or to be aware of?
Please. I mean, I won't go into particular quotes unless you feel it's useful. If I could just go through key points for each of the appeals. So, first, to show you to LCC's Appendix 2, Blainscough Western Council. This was a specific challenge to LCC's methodology in relation to the straight line or walking distance. And I would refer, Madam Inspector, to the findings of the inspector in that case in terms of the outcome. To draw your attention to
This one was in relation to primary places, is that correct?
It wasn't, yes.
Rather than secondary school, wasn't it? But effectively, it's the methodology.
It's the methodology.
Lines versus
Absolutely.
safe walking.
It was the principles of the approach that were challenged rather than the type of contribution required.
It helps, ma'am. I think the relevant paragraphs are then set out in paragraph 3.1.7 of Mr. Terry's statement. So you'll see them there as well, obviously. So paragraphs 26 and 27 of the appeal decision.
moving on to draw your attention to LCC Appendix 3, Land Garfield Farm Inspector's Report. The inspector found that LCC's approach was in line with its adopted and published methodology, and therefore a reasonable request. Please, if I could draw your attention to page 12, the inspector's report, where it says, "I'm not persuaded on the basis of the evidence before me that the council has departed from its adopted methodology. It is reasonable for the council to request the full contribution towards mitigation." Apologies, paragraph 48 and paragraph 50 of the inspector's report.
What were the actual areas of dispute in that particular case?
It was a challenge in terms of there was basically an alternative assessment approach proposed that was not in line with LCC's methodology. LCC maintained the position that they should follow the published methodology.
Okay.
Not in this case. Not in that case. It is.
I think it is. I think if it helps you, ma'am, I think it's fair to say, as far as I'm aware, the only one that does these points is the Appenzell.
First one, yeah. So there's that verbal on lathe, he's done it, yeah.
There are points.
Right, okay.
Moving on, LCC Appendix 5 on Blainscough Coppull. Again, this was a direct challenge about whether LCC methodology would be viewed as a sin. Draw your attention to page 18. Paragraph 91. And finally again, Appendix 6. The land southwest of 51 Waterloo Chorley, was challenged with whether the LC methodology would be the test of still. Page 6, paragraph 35.
Right, okay, thank you. Mr. Powell, do you have any comment on those decisions?
The only comment I would make is that only one of them dealt with even part of what we're looking at here. So I'm not certain the relevance of the other four, except as a general point. But on the Appenzell, we don't know what the appellant's arguments were. What I would put forward is that the Lancashire methodology refers to the DFE guidance. It refers to giving effect to a reasonable walking distance and then applies a radial distance. I would submit that reasonable walking distance, the DFE national guidance and walking distances is the appropriate thing to look at, and that's what should have been given effect to.
Right. Okay, thank you. Right, can we have a look at some of your other additional evidence, Mr. Powell? And you can tell me what the relevance of this is. I'm looking at the map here, South Wales High School GPA 21 to 22. Can you explain that to me, please? Why have you submitted that for my consideration?
That's showing that this particular school, which is the catchment school for the development, it shows that this pupils resident in this area have priority access to those places. It's the geographical priority area for admissions to that school. It doesn't include the Wigan area. It does include Bolton, some areas of the metropolitan borough of Bolton. So yeah, it is providing access to places across borough borders.
Just just excuse my ignorance here, but what exactly is this geographical priority area?
Okay.
How is it formulated? Who does it? What's its status?
I'd have to check as to whether it came from the school or was originally a Lancashire, because obviously academy schools used to be community schools. So it is the admissions. It's map that is used for the school's admissions. It is consulted on. It's approved by the admissions authority, and it shows the geographical priority area is looked after children and children with a statement of special educational needs.
Right.
It is
Do
pupils
you know who does this? Who produces this map?
That's come from Lancashire's own website, because I think Southlands is a community school.
It might be worth me just providing some
That would be helpful, Mr.
Yeah.
Terry. thank
So
you.
basically, in terms of pupil access, in terms of our admissions, how parents access school places for their pupils, Mr. Powell touches on it. I think he suggested it would be a third admission criteria. I think he touched on looked after children, implying that it would be a third criteria. We don't know what admission criteria will be for an academy. There's only one maintained school in Chorley, so we have to assume some flexibility in terms of the admission criteria. But geographical priority area is the determining factor in terms of distance travelled by pupils. So it's about when we talk about who has priority to access a school place, the geographical priority area would be what carries weight in that circumstance.
Right. And how does the school use that in setting?
So that, as Mr. Powell mentioned, that would be consulted upon initially, but they would then publish that geographical priority area as part of their admission code. So they would specify, for example, if it was to Chorley School, they might, for example, identify people from Exton as having a certain priority. That would then obviously be used as a measurement when there was any challenge in terms of more pupils seeking places than the availability of places. So it's one of the criteria that's assessed. We
Right,
don't
so
know
it
what
forms part of the school's admission policy, effectively. So that's their catchment.
it does, yes.
Right. Now, Mr. Powell's point that it doesn't include Wigan.
I'm not clear on what point's being made, sorry.
My question is, why is that the case? Why does it include Bolton, but doesn't include Wigan?
Well, that's something that the school sets. So from our point of view, we can try and influence those positions, but those are set directly by the school, particularly for academies. We can try and influence them, but as to a school will identify where its target market is. Apologies for using the term market, but they will identify where their target is, and they will determine their admission criteria based on that. Or alternatively, if, for example, there is a new development, they might want to expand their geographical priority area to ensure that the new development is part of their catchment.
Right.
We can't say why a school would include Wigan schools or Bolton or vice versa. That's something that's dictated by the school or academy.
Okay. Having GPA map like that, how does it affect this development site? So children potentially going to Southland School, how would that impact on the assessment that you've undertaken? And particularly Mr. Powell's view, we should be taking into account Wigan School.
I mean, I think I would move us back to the point about our statutory responsibility for children. A geographical priority area for a school that's only an influencing factor in terms of projections. So to go back, a geographical priority area will have some bearing on which pupils access school places. And then to go back to what I referred to previously about using past trends to provide future projections, that's where that information would come in. So it's brought in as a past.
Right, okay. So would a GPA set like this for that particular school, would that suggest that they wouldn't accept children coming from Wigan based on their admissions policy?
It would just be how they would score it. So basically, if you have a large number of pupils, it gives them some credit.
Right. Right, okay. So Wigan children will be bottom of the list effectively.
Yeah, apologies. Yeah, it
Yes.
varies.
Yeah. Mr. Powell?
Yeah, having just quickly checked Southland's admission criteria, it is the third criteria is the geographical priority area combined with siblings, then geographical priority area without siblings, and then outside the geographical priority area. And the point we're trying to make here is our pupils will be resident in Lancashire, and as we don't disagree with Mr. Terry that his duty is to provide places for Lancashire pupils in Lancashire schools. Our pupils will be in the geographical priority area, will therefore have priority over anybody from Wigan except looked at a child or special educational needs. And we know that the Lancashire forecasts include Wigan pupils. So the Lancashire forecasts that show that there may, depending on your assessment of walking distance, that shows that there will be a need for places includes Wigan pupils. And we say that that is, as per the Malpass decision, is not relevant for Wigan pupils. They need to be discounted. This development falls within Lancashire. They would get priority over the Wigan pupils, and therefore there is no necessity for new school places as a result of this development.
Apologies, Madam. Can I just come back on a couple of
Yeah,
facts?
can do.
I think Mr. Powell was referred to one school. We have 4 schools within our system. He's picked 3 schools or academies which will have different admission criteria. He hasn't fed any information back on those schools. And I think the other thing to mention, priority areas, in terms of priority admissions, he hasn't picked up on the fact that that siblings would also have access. So when we talk about past trends, siblings are a high priority in terms of admission code. So anyone who's already got, so any Wigan pupils that have already got a child in a Chorley school, any siblings to those will have a high priority in terms of accessing places. So to suggest that we shouldn't then incorporate those trends into our projections is likely to leave us at risk in terms of future provision.
Can I just come back on that siblings point, which is that out of geographical priority area, siblings are given a lower priority than geographical priority area pupils. So even if they are admitting pupils from Wigan,
on what do you base that? Is that written down somewhere?
I've looked at the Southlands.
Right, for Southlands, right, okay. So the admission policy for Southlands.
Yeah. And the reason I've focused on Southlands for the geographical priority area is that's the one that this development falls within. Right. So if we are talking about where pupils from this development would have a right to access a place and would be able to obtain a place, that is why we have considered Southlands.
But it's not the only school, is it?
It's not the only school within a 3-mile straight line radius of this development, of 2 and a 3-mile walking distance in Lancashire. But it is the geographical priority area.
Right.
Can I just add one further fact? Southlands uses a straight line, not walking distance, to measure its geographical priority area. So there are other examples of where the straight line radius is being applied in terms of school provision.
Yeah, that's quite common in Lancashire, isn't it? Yeah. Okay, so that's helpful on that point. Thank you. Now, finally, Mr. Powell, you've included a copy of the admissions policy for Holy Cross Catholic High. Yeah. So what do you want me to note from this? We can recognise the faith school. Mm-hmm. Mm. Right, okay, so there's nothing else you want me to be aware of on the back of that particular document? Mr. Terry, do you want to say anything about that?
I mean, I just picked up, it seems to be something of an anecdotal example at 2.1.7 to kind of suggest it's unlikely that local schools would access it seems to be an anecdotal statement. I'm not sure how that's been backed up.
Okay. Do you want to comment on that now? We'll leave that one. Right, okay. Right. I think that's probably all I need to ask in terms of questions. So I'm going to ask both parties now, is there anything we've missed? Anything else that you want me to be aware of as we come to a close? So I'll go to Mr. Terry first.
Just Education Act specifies our statutory duty, and that is to provide a latch pupils. I think further to that, evidence for distance point, I would just make the point that there is no set guidance in terms of the requirement. We have a published methodology, and we can maintain the methodology for every application. Thank you.
All right, thank you. Mr. Powell?
Thank you. I'll point out those in reverse order. The 3 mile distance, you say that it's clear in the methodology that we're trying to give effect to the DFE guidance. The DFE guidance is clear as to what a reasonable walking distance is, and that is what we have applied. In terms of, also in terms of that, Mr. Terry earlier mentioned about access to the site and that being a somewhat nebulous concept. Of course, details of access are part of the planning application or planning appeal. So that's not really a nebulous concept. In terms of the out of catchment pupils, we say that the Malpass decision is clear about whether that, the relevance of number of out of catchment pupils. We agree with Mr. Terry that Lancashire duty is for Lancashire school places, for Lancashire pupils. We say that there are numbers coming in from Wigan. It would have been helpful had that been clarified by Lancashire. And in the absence of them providing information that should be considered necessary to determine whether a contribution meets the SIL test, the default should be on them to provide the information and to prove that it is. We say that there are pupils coming in, as Mr. Terry has said, it's in there. Inward migration is in their forecast. We say that that's fine as far as the forecast methodology goes, but that's not relevant in terms of providing the necessary number of school places as a result of this development. Our pupils would get a place, Wigan pupils wouldn't. It is not Lancashire's duty to provide those places. In terms of Wigan capacity and forecasts, you've heard our arguments. We've used the same base data. Mr. Terry's argument is to use a January 2021 capacity figures without the January 2021 corollary forecast figures, and we say it's better to use a single base line data.
Right, okay, thank you very much. Anything from any of the advocates to finish off?
I think as I understand it, I don't follow the methodology, so that's why the complaint. But certainly, as I understand the answers that have been given, if one applies our methodology, you get to the results that we've arrived at. I think it's accepted by the authority.
Mr. Pontra, Mr. Cannick, any final comments from you?
No, Ma'am, our points don't get better by repetition.
That's fair enough. Okay then, right. Right, well, thank you very much, everybody. That's all I need on terms of education contribution. So that's all the business we have to go through today. We are back tomorrow at 9:30.
Ma'am, can I just mention tomorrow, I apologise for interrupting. I have two motivating factors for just next timetable. The first is you've asked us to put closings down in writing.
Yeah.
And so my first motivating factor is what I can do to best assist you in writing these closing submissions. And the second motivating factor that I have is to try and get some sleep at some stage between now and 9:30.
We all need some of that.
Now, as I understand it, I have Mr. Hoyle coming
Yeah.
at 9:30.
Yeah.
My question to you is, could we factor in some time between Mr. Hoyle and closing submissions? So, for instance, saying closing submissions not before X time,
Right.
which might at least afford me and my learned friend perhaps a couple of hours. Now,
Right, okay, well,
I'm
we can
not
tomorrow-
going
sorry.
to advance that too forcefully, but I would be grateful for any assistance.
No, I'm happy to discuss it because we do have capacity tomorrow. We have plenty of time. We are fortunate in that regard, this inquiry. Yes, we have Mr. Hoyle coming first thing. We then have our round table on conditions and navigations. I don't think that should take too long, hopefully. And then there's closing submissions. So how would you propose, when exactly in the day would you want the break? Would you want your time before conditions and obligations or after that? What do you propose?
I posed a slight question to the answers whether I'm here for the
Yeah,
conditions section.
this is what I'm wondering.
But I think what I possibly have in mind is sort of closing submissions not before, say, 12:30. So we could have conditions, maybe an early shortened lunch, come back at 12:30. Mr. Pontus tells me he's going to be half an hour, 40 minutes,
Yeah.
that might be an hour.
I thought we discussed in our
Turning up
CMC,
tomorrow
sorry,
or
Mr.
something.
Cannock.
No, no.
Mr. Cannock, I'm sure we discussed in our CMC that we're looking for a half an hour for closings
Well, I'll do my best.
or thereabouts. I mean, if it creeps into 40 minutes, I'm not going to quibble, but or thereabouts, please. Yeah.
As Mr. Carrick said, points don't get any better through repetition, do they? For my part, I'm completely content with Mr. Cannock's proposal. Whatever is most convenient to you. We could start off with followed by conditions and section 106,
Yeah.
then a break
Early
of a couple of hours.
And then, yeah, if you want to start at 12:30 for closing submissions.
We should be able to get through.
Approximately 2 o'clock-ish, say. Hour and a half closing in total. Yeah.
Mum, I don't want to be too prescriptive because I don't know how long things will go, but I'm
No.
just asking, I suppose, for in the order of a couple of hours, perhaps.
Yeah, no, that's fine. All I'm thinking is...
That might
if
help me
it's site
edit them down, Mark. Who knows?
Might well do. Well, it will be excellent. No, I'm just thinking about site visits and wanting to be on site round about 3 o'clock-ish, which is the school pickup time. I want to view traffic around that period. So I would need to leave here at sort of 3, something like that, to make sure that I can do my site visit at that time approximately. So certainly 12:30, yeah, I would think. Is that acceptable to you, Mr. Ponce? Is that...
Let's aim for that. And
if it
we
gets to 1
can,
o'clock, then maybe we'll
yeah,
set
we
it to
can
1 o'clock.
review,
We can be flexible
depending on
tomorrow.
what time we finish getting through the other business tomorrow morning.
I certainly would have thought you'd have at least from 11 till 12:30, if not earlier. Yeah.
Well, I'm very grateful,
fine
Mum.
with
Thank
that.
you. Yeah.
I'm fine with that. No problem at all. Okay, right. Well, we'll do it in the morning anyway and see how we go. And then if we have to revise the 12:30, we'll push it back to 1 o'clock or something. We'll see how we go. Okay then. Right. Thank you very much, everybody. We are adjourned for today then, and we're back here tomorrow at 9:30.